But in fact, the petitioner has
Okay, we'll call for the CD. Let's see.
Mentally disturbed girl, madam.
Hmm? Until a disturbed girl, yes.
maintained is a my story is something.
Heard Mr. So and so, Senate Council, and Mr. Parasa, application on the so and so. The matter, an FIR was lodged on 10/1/2026. FIR was filed by whom, father? FIR was filed by whom?
Affair is filed by
Father or somebody else?
the
FIR
informant.
was-
She is maintaining her.
Hmm?
Informant, she is staying in the house of the informant,
Okay.
Guardian, madam.
guardian.
And an FIR was filed on 10/1/2026 by one Vijay Modak, the guardian of the victim, alleging that she was raped by the accused applicant. Call for the CD, let the matter be fixed on
2nd of March.
2nd of March.
Second case, he is soon arrested.
Hmm?
The same date. In another case, he soon arrested.
Sworn arrest
Yes.
in different case.
Different case lost by the police lordship. My lord, there is some
Similar, same FIR.
different FIR
Ah,
lost by the police
ah,
with the allegation that lordship he tried to escape from the custody of the police, and subsequently he was shot and his leg was lordship got bullet injury, subsequently taken to hospital.
okay, heard Mr. So and so. And so this is an application under so and so. On 11/1/2026, an FIR was lodged by one Kosik Dole, alleging that when his staff was escorting the accused applicant, he tried to escape, and thereafter the police had to no, they don't write like that. He tried to escape and police had to stop him with force, whereby he sustained certain injuries. Call for the CD, let the matter.
Same date, madam.
Same day, same day.
Second.
Second.
But both the case may take together lordship.
It will come together, I mean, both the cases.
Entry.
Please, your lordship.
Yes.
I am in custody since 15 days as on today, lordship. My lord, 48 notice was not served on me.
Heard Mr. So and so.
CD required to verify madam. Fake currency note.
So and so, the learned council. Application under so and so. An FIR was lodged on 19/1/2026. Alleging that fake gold and fake Indian currencies were recovered from the accused applicant. Call for the CD, let the matter be fixed on
Next Friday, 27.
Obliged.
27. It will be difficult. I mean, keep it some
Madam. Then 2nd or 5th.
5th of March,
Then lordship, it may be on 6th, lordship.
6th of March.
Obliged.
It is your lordship. The regular bail application, lordship. Petitioners are behind us for last 28 days. Offense 1031 is there, lordship. So file for CD and PM report will be required. FIR page number 14, lordship.
From Bokakhat, madam.
It's a minor girl,
No, lordship, it's a murder, lordship.
Murder case.
murder case.
103. 7th of March, madam.
Okay, heard Mrs. So and so, the learned
Bokakhat.
council opinion. Also heard so and so.
On second,
Then an application.
So case.
The case relates to murder of murder of a lady who was supposed to be in relationship. Yeah, she was in relationship with whom?
His actually allegation is that the petitioners are in relationship. Lordship.
Hmm.
And the Lordship, the deceased is the husband of the petitioner number 2.
This is the husband of
Petitioner number 2, Lordship.
the case relates to rape and murder. Rape also, no?
Only murder.
No, murder of the victim. Call for the case diary. Let the matter fix on
Fifth.
5th of March.
Oblige. PM.
I was.
Item 44, along with item 20.
Well, it can maybe taken at the time of malat bail hearing, malat 20.
Okay.
Item 6.
6 malat regarding malat whether any case pending or not report we have not yet received malat. Maybe come after some time malat. I will take instruction.
Today itself.
We have sent.
No, it's about charge sheet.
No. Whether any case FIR.
Okay, that FIR has been lodged or not.
No.
Okay,
Or
we will take up after some time. Let him give us instructions.
7.
Well, case has been charge sheeted against me, though in the FIR my name is not there. Even then, when I want to appear, my non-bureau warrant has been issued, my lord. So, my lord, I pray your lordship, my lord, I may be given an opportunity to appear and I may be given some protection, my lord.
Malat, when non-bailable warrant is issued, malat. So, malat, during pendency of that order, malat, how malat AB can be granted? Malat, that order has to be quashed, malat. He has
Go
to
for
come-
cancellation of the bail, cancellation of the NBW.
Criminal petition has to come, malat.
My lord,
An AB application, it will be difficult, now. How can it be
there is
given?
no,
An
my
NBW
lord,
order is there,
Probably there is no bar, my lord.
no, on the face of it,
Your lordship may peruse the scan copy, then if there is a material.
No,
then
no, I mean, on the face of it, I mean, if the order is still there. I mean, this is not a case, I mean, where, I mean, very unusual circumstances. It's not a case of unusual circumstances. If there would have been an extreme need of this, then it would have been different thing. It's not an unusual circumstances. You go and appear there and ask for a cancellation of the NBW.
The question is that in that even I will stand behind the bar. That's why I have come back for protection.
No, correct. I mean, but I mean, this is an AB application.
And this AB.
AB application NBW has been issued.
In the cost schedule,
Already.
it should be malat, it should be malat under 482. Here it is mentioned as 438. 438 nowadays malat.
482 and 438 the same thing.
Same that now code of criminal procedure already gone, malat.
Well,
1
let
year
it come
back.
next week, but I will satisfy your lordship.
You go and appear there. I mean, if on the face of NB,
But I
On
have
the
come
face
back
of-
there to face the trial.
why didn't you then, why didn't you go and appear? I mean, you face the trial.
No, face the trial, I am innocent, I was innocent. In this case.
No,
clearly
why,
it is
and,
not
okay,
possible.
where is that NBW order?
Well, that is in page number.
Page
17,
number?
kindly peruse, my lord.
Page number?
17 and page number 18.
Why
Last order
NBW
is
has been
valid.
issued?
29, 2024.
Then 19, 12, 25. It was not served upon me. That's why I have come here. Now also not served. I got the information from police station, then I am here. Next date is 13/3/6/26, madam.
No, you go and appear there.
Give me some protection that I will appear.
No, protection.
Then my date will come next week.
Okay, next week on the prayer of the Lord, council appearing.
Otherwise, malat,
Let the matter be
this
fixed next week.
petition is not maintainable. How the registry has passed? 438.
Yeah, why you write
CRPC
438 for 38 now? It's not existent now.
My lord,
This
my
applicant-
brand is not correct, my lord.
No,
Why?
438 CRPC gone 1 year back, sir.
Now, why you are
438
filing it
CRPC
438 now?
There is gone back, no doubt.
No,
But
now
what is the wrong? It is a case of 24, before your enactment.
No, Mr.
Petition filed now.
Mr. Biswas, now, see, now CRPC has gone.
That's true, my lord.
And then I mean, CRPC has gone now.
Well,
So,
in
but,
many
but,
cases,
no, you
CRPC
can,
own
you, no,
cases are
you,
pending
see, you,
still.
no, you can mention those sections, I mean, under which you are charged, that is different thing. But
Petition
now the
filed.
petition has been filed, the petition has been filed,
Now.
I mean, now only, now that is non-existent. So that
But
much of care
it
is to
in
take.
the old section of the.
No, the old section you can mention there, that's a different thing, but.
302
but
is there, that's why.
Mr. Biswas, I mean, this petition should have been filed under the new act which is active now, not on the, not under the act which has already gone. I mean, mentioning about the section because it was registered registered in 2024 under the old act, that's a different thing. Making a statement, pleading, that's a different thing. But as far as this petition is concerned, it should have been filed under the new act. It could not have been filed under the old act. That much of care you should take. Please see in the next week. That this matter, please see the next week.
May I please, Your Lordship? Your Lordship, this AB is filed in connection with NDPS case number 509/2025,
Hmm.
pending before the Court of Additional District Judge number 2, Kamrup Metro. Herein, my lord, I have been served with a notice under section 67C of the NDPS Act. I am not a FIR named or complaint named accused person. Only material against me is that the one of the arrested accused person, Anshu Kumar, was using a SIM card and that was registered in my name. So after the issuance of the notice, Your Lordship, notice is at page number 19, Annexure 1. I filed a reply to the Additional Directorate Narcotics Control Bureau that as I was directed to appear on 1st December, but I received the letter on 16th, I may not be able to appear up to the first week of January 26.
Where do you stay?
At page number 20, Your Lordship.
No, where do you stay?
Bihar, Your Lordship.
Bihar.
Yes.
Okay.
Thereafter, when no reply came from the Narcotics Bureau, I filed an AB before the concerned trial court. And by order dated 3/1/26, that is Annexure 3, page number 23, I was granted interim bail and directed to appear before the concerned IO on 8th. And thereafter, I came to Gauhati, but on 8th, the concerned IO was not present. I could not give my statement. Other officials also said, no, we can't take your statement. And I appeared before the court below on 8th. That is at page number 25, Annexure 4 is the order dated 8/1/26. And thereafter at Annexure 5, page number 26 is the petition filed by me before the court regarding the incident that on 8 I could not appear and annexed therewith some railway tickets. But since I have to go back to Bihar, on 10th I return back. But thereafter on Your Lordship 7/2/26, my anticipatory bail application was rejected. And hence this petition.
Rejected for what?
Rejected means Your
If I may-
Lordship, page number 40, paragraph number 16, that the petitioner has neither pleaded nor demonstrated that there are reasonable grounds for believing that he is not guilty in the alleged offense. And nor has he established that he is not likely to commit any offense while on bail. The twin conditions mandate under section 37 of the NDPS Act.
Lordship may read from page 39, Lordship, paragraph 14.
Paragraph 39, paragraph 40. Further, may I, Lordship?
1 second.
Yes.
Yes.
This paragraph number 39, page 14. It's further the report.
Now, where is the earlier order wherein the anticipatory interim protection was given?
Page, Lordship,
Page, this
page
thing.
number 23, Your Lordship.
What is 34?
Lordship.
What is page 34? This is the application one. No.
No, the page 34 is the order sheet, Your Lordship.
Earlier was the interim order.
Earlier was the interim, Your Lordship, page order 3-1.
Page? Page 24, 23.
23, Your Lordship. Sorry.
What is page 25?
25 is the order dated 8/1/26, Your Lordship.
No, what is that order?
Your Lordship, the land special public prosecutor.
So it
representative-
was extended.
Yes, Your Lordship. And report was called for.
What report was called for?
The-
Whether he has appeared?
Your Lordship.
What report was called for?
Yes, so well, his involvement and whether he appeared or not.
The report did not come.
Report came after 4 days, Your Lordship.
Hmm.
That is
Then where is
on-
the report?
Lordship,
The report is
see
not
page
available here.
36,
Hmm.
the contents of the report are given in paragraph 7.
Yes, it says that, I mean, he did not go, there is no material to show that he has gone there and
Yes, he
appeared.
has in fact not come.
Hmm?
He has in fact not come to the authority.
But he said that like he went there, but like.
Yes,
said that
I have
No.
extra tickets also, Your Lordship. My journey tickets, Your Lordship.
Where is the tickets?
Page number 29 onwards.
No, but who appeared? Who filed the anticipatory bail and this thing?
He is, I am the petitioner herein, is the material against him is that only
No,
one.
do you tell me one thing?
Yes,
That,
Lordship.
I mean, you said that you travel by train, right?
Yes, Your Lordship.
You travel by train, the train ticket is at page
From
33.
29 onwards, Your Lordship.
33,
29. Your Lordship.
29 onwards. Yes, so you said that you came by train.
Yes, Your Lordship.
Then you went to the office of
Yes, sir.
NCB. Then NCB did not record your,
Yes,
he was,
because the
IO was not there.
Yes.
But report says something else.
He did not appear, Lordship.
But tickets are there.
The tickets are there, but whether he has appeared, Lordship. And
The report is there. Report is
No,
there
Your
somewhere. Huh?
Not with here. with-
Report is there in the, I mean, you won't be having it now.
I do not have it today, but
Mhm.
that contents of the report is quoted there in page 36.
Page 36.
Page
Oh, no,
36.
that I have gone through.
Yes.
36.
Yes, sir. Yes, sir. Yes, sir.
But charge sheet is not filed against him.
No.
So only investigation is going
Yes.
on. And how 37 will come? When the charge sheet is not against him, only, I mean, now 37, how 37 can be brought in? NDPS Act.
Yes, that is true, Lordship. But so far
Still,
as
the-
summoning him-
still the investigation is going on.
Yes, yes.
Commercial quantity was recovered from somebody else. Only thing is that linking him is that a SIM card was found.
Lordship.
No charge has been framed against him, or no
As
charge
of-
sheet has been filed against him.
As of now.
Now 37, how 37 will be
37
applicable?
would not,
Hmm?
sanction would not come in, but that would not preclude the authorities from investigating.
No,
That is why
investigating, of course.
that is why-
of course.
Notice has been issued under section 67.
I'm ready to appear again.
Let him appear.
If he appears. Because
Let him appear.
previously
No,
also
we'll direct
a
him to
chance was
appear.
given to him. by the
We'll
trial
direct
court.
him to
ready.
appear. We'll direct
Lordship
him to
will
appear.
fix the date when he will.
Yes,
appear.
yes. We'll fix a date and let him appear.
Yes, yes.
I mean, there is nothing, I mean, only thing is linking is the SIM
Yes.
card. Investigation has to be done. So he will cooperate with the investigation.
yes, sir.
The contraband was not seized from him. I mean, it is not on the basis of any statement, but only basis of the material which was found against him. So we'll not keep it pending. Let him
Yes,
appear.
yes.
Let him
But
appear.
my only prayer is Lordship will fix the date when he will. appear.
Yes, that will. Heard, Mr.
MR Sodial. MR Sodial.
M.R. Sodian, the learned counsel appearing for the accused applicant, also heard Mr. R.K. Dek Chaudhary, learned deputy solicitor general appearing for the NCB. This is an application under so and so.
Sorry.
Where is the charge sheet? Page?
It's on page 43 onwards.
The prosecution case, as has been narrated in the complaint dated in the complaint in connection with NCB crime number 7/2025 dated 23/6/2025. Filed before the district and sessions in bracket special judge Kamrup Metro Gauhati inter alia is that on 23/6/2025 at about 1000 hours on receipt of a reliable secret information that two ladies, namely Guria Devi and Manju Devi, were carrying substantial quantity of heroin concealed in soap boxes, and they were traveling And they would be traveling from Gauhati to Bihar by a bus. That another person, namely Pankaj Kumar, a resident of Guwahati, who is the associate of the receiver of the heroin, will also come to drop the ladies at ISBT Guwahati. That that on receipt that on that in pursuance of office order of the same date, that is 23/6/2025, the police in a team of NCB officials went to the ISBT. That that on approaching the aforesaid ladies, one of the ladies, that is Manju Devi, admitted of carrying heroin in her bag, which was kept on her seat. That on search of the bag, many plastic soaps were recovered, and opening recovered wherein suspected heroin were found inside those soap boxes. The NCB team recovered that on approaching the other lady, that is Guria Devi, she also admitted of carrying suspected heroin, and later on recovered and recovered certain soap boxes containing suspected heroin. That after proper charge of the aforesaid two ladies, the NCB team recovered a total of 48 number of soap boxes containing a total of 0.54 kg of heroin. Full stop. After receipt of such complaint, NDPS case number 509 of 2025 was registered. Registered, full stop. Next para, after investigation. After investigation. mm, the complaint under section 36 of NDPS Act dated 23 that NDPS Act that is NCB crime number 7/2025 dated 23/6/2025 was filed. Next para. During investigation, it was found that one SIM card which has been used by one of the arrested persons was registered in the name of the accused applicant. Full stop. Accordingly, a notice under section 67 in bracket C of the NDPS Act 1985 was issued to the accused applicant who is a resident of Bihar. Full stop. On receipt, in my next para, it is submitted that on receipt of the aforesaid notice, the accused applicant traveled to Gauhati to appear before the NCB officials on when? On where did you write? What have you mentioned about that
Yes, Your Lordship.
paragraph?
Paragraph number, Your Lordship, 6.
6.
That's 5 and 6, Your Lordship.
However, on the date fixed for for his appearance, that is on 1/12/2025, the accused applicant could not appear, and therefore he intimated the NCB authority by his letter dated 18/12/2025.
Yes, Lordship.
18/2025 about his inability to appear. And therefore requested. Where is your letter?
Annexure 2, Your Lordship. Page number 20.
Page number?
20. 20. Second para, Lordship.
Intimating that he would be able to appear before the NCB authorities in the first week of January 2026. However, it is submitted that no reply to the aforesaid letter was received from the NCB authorities and authorities. Therefore, he Therefore, when did you travel? You didn't write anything. Therefore, therefore he traveled to Guwahati on,
Date of the ticket, your lordship.
hmm?
Page number 29, I didn't write anything, but your lordship may turn to page number 29. Journey ticket.
Hmm.
The date is 6/1/26. On the top,
6/1/2026.
yes, your lordship,
Okay.
near the
He
QR
traveled to
code.
Guwahati on 6/1/2026. And but you have not stated anything that you have went there.
Yes.
Where have you stated?
Your lordship, paragraph number 5, your lordship,
Paragraph number 5, what you,
that by order dated so and so, so and so.
no,
so
no,
and so.
order, no, I
No,
mean
no,
like,
I'm going, your lordship. As per the direction of the land code below, the petitioner approached the Narcotics Control Bureau, Gauhati Zonal Unit, to appear before the IO of the Narcotics Control Bureau of so and so number, and unfortunately said IO was,
no, after coming to Guwahati,
Yes.
you straightway filed the anticipatory bail.
no, my lord,
Then?
Lordship,
later,
page 6,
prior,
it's a part of paragraph 5.
Hmm.
He appeared before the court on 8/1.
Hmm?
He appeared before the court
Hmm.
on 8/1. He does not say he appeared before the officer concerned.
So, I mean, was there any date on 8? No,
yes, it was fixed,
it was fixed on 8.
yes.
Okay. Since submitted that since a date was fixed for the case on 8/1/2026, he appeared before the aforesaid aforesaid trial court on 8/1/26.
May I just?
Hmm.
First, he says that the notice was issued to him, which was received after the due date. Therefore, he writes a
Letter.
letter
Hmm.
that is at Annex
Hmm.
2.
Hmm.
Then he says he did not receive any confirmation or any reply to that.
Hmm.
Then
Yes.
how
Then
the-
he traveled, he said.
Then how did he? say
Then I
that-
filed the AB.
No, no, then he appeared before the.
No, after the filing of the AB, when no reply came, I filed the anticipatory bail before the
No,
trial.
you are confusing. See, I mean, you initially said that you wrote a letter.
Yes, your lordship.
You didn't get any information.
Yes.
Reply back.
Yes.
Then you traveled to Guwahati.
No. Prior to that, I came
That
to
then
Guwahati just-
then you were not clear. You were
No,
not. I mean, you were submitting. I mean, a few minutes back you said that you came to Guwahati.
No,
Then-
after the order from the court, I again came to Guwahati. Order dated 3/1/26.
Again came to Guwahati means.
Means prior, first I filed the AB, I came, thereafter,
No,
after,
Before filing the AB, you said that you went to the police officer, then for that NCB official,
the direction.
NCP official were not present.
No.
Then you filed the AB.
No, your lordship, I may be, because of I am not feeling well also today, I may have confused. First, when I filed the reply,
No, when you tell me the facts properly,
Yes.
I mean, you came to Guwahati
Yes.
and straight away you went to file an AB.
yes, your lordship,
Straight away file an AB
Yes,
after coming to Guwahati,
Yes, Your Lordship.
before approaching them, right?
yes, your
So AB, you got an order to appear before
IO,
IO on
on or before 8/1.
8/1.
Yes.
Okay, you said like that, and you said that you went there first. It is submitted that after arrival in Guwahati, the accused applicant filed an anticipatory bail application before the learned additional session judge number 2, Kamrup Metro, wherein the aforesaid, wherein the additional session judge directed the accused applicant to appear before the IO on or before 8/1/2026.
Page 24, Lordship.
Page 24 is, I mean, this 3/1.
The first order,
3/1.
page 24,
Hmm.
he was granted bail. The petitioner accused shall appear before
Within
the con-
15 days, your lordship.
Within 15 days, no date.
And the
was-
next date was fixed as 8, your lordship.
So you're confusing the text. I mean, now I'll have to read the whole
Your lordship,
whole petition.
Yes.
I mean, if you expect me to read all
No,
the pages, then
I apologize.
Huh? Then why are you saying that before eight, you are
It
saying?
was fixed. I apologize.
The learned additional session judge directed the accused applicant to appear before the investigating officer within a period of 15 days while granting interim relief to him. It is submitted that the accused applicant went to went to visited the office of the NCB officials, NCB officials on 8/1/2026. However, since the officer concerned, however, since the IO was on leave, his statements could not be recorded. Full stop. It is submitted that the accused applicant was in Guwahati till 1/10/2026. And thereafter he returned to his native place, Bihar. Full stop. Thereafter, the learned court of additional session judge number 2, Kamrup Metro by order dated 7/2/2026 disposed of the anticipatory bail application of the accused applicant by rejecting the same. Rejecting the same. Faced with the situation, the accused applicant has approached this court for granting him anticipatory bail so that he can appear before the NCB authorities. Full stop. Full stop. He submits that the learned counsel appearing for the accused applicant submits that the only fact which links him to the offense as alleged in the complaint is the finding of a SIM card which was registered in his name from the possession of the accused applicants. He submits that no contraband material has been seized from him, or there is no material to suggest that he was involved in any way in the crime so alleged in the complaint. He further submits that his intention of cooperating with the investigation could be seen from his traveling to Guwahati as well as visiting the office of the NCB officials to record his statements. He submits that due to financial constraints, he had to go back to his native place, Bihar, and he is ready to appear before the NCB officials and provide full support in the whole investigation of the matter. Full stop. What will be your this thing?
Lordship, if we let it be on a fixed date, Lordship, but he will appear on that day.
Mr. R.K.D. Chaudhary, the learned counsel, learned Deputy Solicitor General of India submits that if the accused applicant is willing to cooperate with the investigation and he appears before the NCB authority on a fixed date, that same could be considered by this court. Full stop. After hearing the parties, after hearing the counsel appearing for the parties, this court is of the and taking into account the entire facts of the case, this court is of the considered opinion that the accused applicant should be given the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of his arrest by in the event of his arrest by the IO in connection with NCB case number 7/2025, corresponding to NDPS case number 509 of 2025, he shall be released on furnishing of a bail bond of rupees 50,000 with a local local security of the same of a local security of same nature to the satisfaction of the to the satisfaction of the, which court is this? Additional session judge, satisfaction of the additional district and session judge number 2, Kamrup Metro, subject to the following conditions: that the accused applicant shall appear before the NCB. When can you appear?
Lordship, is,
I mean, should it be on a fixed date or
Let it-
before?
Let it be on a fixed date, Lordship.
On a fixed date? Okay, I mean, but whether IO will be there or not, that you'll have to confirm. If he's not there, he's on leave, then it will be a problem.
or if your lordship may die.
Let-
Or other, I mean, we
In-
put,
in
Other
between-
person
In
can,
between 2 dates, Lordship will.
2 days will be a little bit difficult
No,
problem.
in between 2 dates. That may be, Lordship.
No,
From-
we'll pass like this, that within a period, I mean, from this order, within a period of 7 days, let him appear.
Yes.
7 days,
Yes.
okay. Shall appear before the IO within a period of 7 days from passing of this order. Full stop. Next, the accused applicant shall fully cooperate with the investigation and shall appear before the IO as and when called for. Number 3, that the accused applicant shall not tamper or hamper, that usual, you write. That will do. I mean, in view of the aforesaid directions, the instant AB application is disposed of.
deeply offensed.
And write one thing, in the event of non-appearance of the accused applicant during the period as mentioned in the instant order, the NCB authorities will be at liberty to approach the appropriate forum for cancellation of his bail.
Deeply offensed.
Item 9.
Lordship, this is a pre-test bill, Lordship. FIR is at page 15, Lordship. 9. Some vague allegations have been made regarding commission of rape. That while she went to the CSP center for withdrawal of money and asked about the preparation of some job card, accused brought her to Abhayapuri and committed rape. Neither place nor any specific allegations have been made, Lordship. Thereafter, a tablet was given to her, then a motion.
Age
She is
13
a married
plus,
woman,
if
Lordship.
applicants.
Informant is a married woman.
Yes, Mr.
Lord, page 13, your lordship may fire for it.
Hmm?
Your lordship, page 13, your lordship is kindly.
Yeah, that I have seen.
Yes, yes, my lord. There, your lordship will find several allegations regarding my lord that he was given a tablet and thereafter.
Not against me, abortion party is against the other co-accused.
Then he became dizziness, and thereafter, my lord, this Saddam Hussein, by taking advantage of this, raped her repeatedly, and after that, accused number 2 also, my lord. Yeah, my lord. And as a result, she has been injured in her private parts, my lord. This
No injury, no injury. Bleedings only. That is part of the abortion type allegations.
So, I am praying, my lord, let the CD come, my lord.
Let the city come.
Right.
I am facing the
Heard Mr.
interim protection.
No,
lordship.
no, no, no,
I
heard
am ready
Mr.
to cooperate, lordship. Lordship, in this case, I have wrongly implicated the informant, lordship, as a case of 64. Respondent number 2.
You were Saddam Hussein, right?
Saddam
Yes,
Hussein, my
So
lord.
you were the main accused.
As
Yes,
per
my lord.
rape, allegation of rape is concerned.
Heard Mr. S.K. Poddar, the learned counsel appearing for the accused applicant, also
MP
upon
Goswami.
this MP Goswami, the learned APP for the state. This is an application under so and so. Then you write the matter relates to an allegation of rape on the informant by the accused applicant. By the accused applicant, full stop. Call for the CD. Let the call for the CD.
Name
let
of
the
the
matter fix.
respondent number 2 may be struck off, lordship. She is not required in 64 case, lordship.
Yes, it's not required.
Lordship.
Just I have inadvertently made a party, lordship. Her name may be struck.
Yeah, call for the CD and this thing, it is submitted that. It is submitted by the learned counsel that, but this is not what, we can't do it like that now.
Yes.
You'll have to file an
Let
application.
this go, lordship.
You'll have to file, no, I mean, why notice will be issued to her? She is not required. You will have
Let's say
to,
it may be struck off.
you'll have to file this thing. You'll have to file an IA to correct it, because this is not the procedure nowadays. We can't do it just strike it off. Anyway, we are fixing the matter. In the meantime, you file an IA for this, correction of this.
CD, in the meantime, CD will call for it.
We'll call for the CD. In the meantime, you file it. In the
Right.
meantime, you file it.
I'll do it.
The learned counsel appearing for the accused applicant submits that there is an inadvertently, the informant was made a party in the instant AB application, which is in fact not required. Full stop. Accordingly, he submits that he would file an IA for correction of the cause title. The same is allowed. Let a matter be fixed on. CD call लिखेंगे.
Not.
Let a matter be fixed on.
27, lordship, if possible, lordship. 27.
Lordship.
27 not possible.
On 2nd,
6th of March, my lord.
6th of March.
If-
6th or 5th.
6th.
6th of March. Sorry. 6th of March. In the meantime, you file it and then it has to be corrected. On the next day only that can be corrected and
Lordship. Problem. 10.
May I please?
yes.
Lordship, the informant lodged this affair alleging various offences, including sexual harassment, criminal intimidation, and attempt to rape. Your Lordship will find the affair at page
Page 9, lordship.
9.
You are named in the affair.
Lordship, accused number 1.
Case number
Is number 1.
He is the prime accused, my
So
lord.
we'll call for the CD. Heard Mr. So and so, the learned counsel, appearing for the accused applicant. Also heard Mr. So and so, the learned AP for the state. Is an application under so and so. The case relates to sexual harassment and criminal intimidation by the accused applicant along with others on the informant. call for the CD, let the matter be fixed on. When?
The same, Lordship, may kindly fix on 6th of March. Sir.
6th of March.
11.
May I plead, Your Lordship? My lord, this is a charge sheet case, my lord. My lord, what happened in this matter, my lord? On the very first day of the consideration of charge sheet, my lord, Your Lordship.
The
page
charge
for-
sheet, you go there, what is what?
Yes, my lord,
you go
kindly
there.
page number 30, my lord.
You go there.
30, my lord, on the date, the charge sheet filed 27/3/24. Kindly for a moment, my lord.
Hmm.
And the next date, my lord, page number 31, 22/4/24. On the very first day, my lord, the NBWA issued against the petitioner.
Now you go there.
My
then.
lord, petitioner is not a, my lord, a FIR named person, my lord. And my lord, kindly come to your page number 39, your lordship, my lord. Because of my lord mentioning that petitioner in a absconding, my lord, in a similar situation, your lordship, my lord, absconder in a charge sheet mentioned, and accordingly NBWA issued, my lord. So, my lord, your lordship, this is a non-bailable of offense, my lord. And in a similar circumstances, my lord, your lordship has granted protection, my lord, to the petitioner, my lord. Same, my lord, the petitioner was shown as absconder, my lord, in that case, my lord.
No, here it will be different.
No difference, my lord. In this case, my lord, the petitioner is not an FIR named person, my lord. His name is not there, my lord. Page number 13 is the FIR, my lord. Not FIR named, my lord. The FIR, it was mentioned that he was a driver of the, my lord, vehicle, and the owner was arrested, my lord. But there is nothing in the, my lord, arrest of the ground of arrest of the owner, my lord. No whisper about the, my lord, petitioner is there, my lord. If he was a driver, the petition owner would have named him, my lord. I have also annexed the, my lord, forwarding report, my lord. There is no whisper that, my lord, the owner has named the petitioner. I am not going to the merit, my lord. I am willing to face the trial, my lord. And I am ready to face the trial, my lord. Only, my lord, because of the, my lord, NWA, I may be given the protection. As your lordship has earlier, my lord, in the similar circumstances, my lord, granted protection, my lord, to the petitioner. There is no whisper, my lord, about the petitioner, my lord. Otherwise, if the merit is considered. There is nothing, my lord, that the owner has named the driver of his vehicle, my lord. Nowhere, my lord, and
No.
all along the petitioner was present in his residence during the trial, and he was not arrested, my lord, during the, my lord, the investigation of the proceeding, my lord. And after the, my lord, when the warrant of arrest was issued, my lord, he was not present, my lord, in his residence, for which, my lord, recently, my lord, when he came back, my lord, in his residence, he came to know, and then when he obtained the record, my lord, he found that, my lord, that NBW issued on the very first day, my lord, for which he is, my lord, if appear, my lord, without any protection. he
Let
will
us
be
see the
arrested.
orders. Orders.
My page number 13, my lord, your lordship order, page number 39, my lord.
Hmm?
Page
No,
30
that I'm not.
My lord, order, my lord, page
Order of the
number-
trial court.
Yes, my lord, page number, my lord, 30 is the first day of filing the charge sheet, my lord.
Yes.
First day, my lord, this is the charge sheet. Charge sheet was kept on record, my lord. And the next date, my lord, 8/4, there is no mention about the charge sheet. And on the next day, 24/24, in view of the charge sheet being submitted in the instant case, NBW issued, my lord. This is, my lord, absolutely against the.
But we don't know,
But if he is any, my lord, aggrieved by the orders, my lord, he has to challenge these orders, my lord.
No, my lord, I am ready to face the trial, my lord.
He will be
I
ready,
am
but that
facing
is,
trial, my lord, on
he has
26.
to face that trial, my lord.
On 26/2, my lord, the case is fixed. And my lord,
Already NBW issued, my lord. And how,
NBW
it
issued,
is
my
a,
lord,
it
but
is a bail proceeding, my lord.
I am, my lord, willing to face the trial, my lord. And your lordship in the similar circumstances, my lord, has given protection.
Let him come with a separate petition.
Page number 39, my lord.
And it's a commercial quantity, my lord, lordship has said.
Page number
Without
39,
being-
my lord, in the same, that was also commercial.
Just let us, let me
Okay.
read it. Charge sheet, you have been named.
Named, my lord. So without being anything, my lord, he will not have been sent for trial, my lord.
I will face the trial, my lord, ready to face the trial.
So may kindly come to the search sheet, my lord.
My lord, if he was a.
Charge sheet,
driver-
where is,
20, page 29, below portion, my lord.
what is his allegation?
Nothing is there, my lord. Only mentioned that at the time of filing FIR, I was, my lord, I fled away. It was in the broad daylight, my lord.
Where is the FIR?
My lord, FIR page number 13, my lord.
13.
Page number 13, my lord. 5 AM in the month of July, my lord, that after sunrise, my lord, in the broad daylight, it is mentioned I have fled away. My lord. driver fled away.
So you were the driver, you fled away. my lord.
He's a driver.
He's the driver, he fled away.
It is
How
mentioned,
can he
alleged,
be,
my lord.
how can he be not liable?
My lord, the forwarding report, the owner did not mention, my lord, that I was the driver man. I have annexed the forwarding report, man. Forwarding report, page number 17, my lord.
Lord, may I kindly see a cough syrup bottle of 6,000 and
That-
33 cartons of Fencidal, my lord. 3,300.
That is right, my lord, but I will face the trial, my lord. If
And
convicted, I
without
will,
knowledge, my
I
lord,
will face the consequence, my lord.
that cannot be a ground, my lord. So much, my lord. 600. Altogether more than, my lord, 10,000 bottles, 9,900 bottles. Only, my lord, 11 bottles come to commercial, my lord.
The charge sheet also not mentioned that the owner had named my name. How they have sent to the, my lord, that I was the driver, my lord. I am a vegetable vendor, my lord. In the charge sheet, it is not mentioned that the owner has named me. Owner has claimed that I was the driver, my lord.
The other case was different. They're not like this case.
No,
Well, that was also
here-
commercial quantity.
No, commercial quantity. He was, I mean, this is he was the driver, allegedly driver, and
Sir.
he fled away.
I
The earlier case was not like that.
My
Fled
lord,
away.
the
No,
owner-
no.
My lord, the owner would have named,
No,
my
no,
lord.
no.
In the
That
charge sheet-
during the investigation, owner need not name you.
Need not
During
name,
the
my lord.
investigation, it has come out that you are the driver.
Owner need not name, my lord.
Why owner need to requires to be name somebody?
My lord, then my lord, I will pray for my lord scan copy of the matter, maybe.
No,
maybe
no,
my
no,
lord,
no, not required, not
scan copy
required,
maybe my lord.
not required at this stage.
Or
All,
whether-
all the materials are before. What else will come from there?
My lord, in the.
No, what else will come from the trial court?
My lord, how they,
No, you tell me what else will come from the trial court?
well, how my name, my lord.
No,
came
from where?
In the record.
No, which document, from which document it will come?
From the CD, my lord. If the scan copy is, my lord, brought, if the CD will be available.
No, this is there, this is written in the charge sheet.
Charge sheet not-
Charge sheet, it has written you were the driver and you have gone there.
Lord, how they came to the
Wait,
conclusion,
no,
my lord.
no.
It is not the owner.
Heard Mr. A. Kadir.
My lord, kindly, my lord.
No,
give-
no,
give
no,
me,
no,
my
no,
lord,
no
2
way.
days
Heard
time, I
Mr.
will satisfy
Heard
your
Mr.
lordship, my lord.
Heard
Kindly
Mr.
give me,
A.
my lord, 2
Kadir,
days
the
time.
learned
I will
counsel
satisfy
appearing
your
for the
lordship, my
accused
lord.
applicant. Also heard Mr. So-and-so learned APP for
Thank
the
you,
state.
sir.
This is an application of the so-and-so, right? An FIR was lodged on 10/7/2022 by one SI, namely Bijoy Goswami, alleging that on receipt of an information of a vehicle carrying suspected contraband materials.
My lord, I may be allowed to withdraw, my lord. I will file an appropriate petition for challenging the NBW.
Please do that. That will be
Yeah,
better for
yes.
you. That will be better for you. You should have done it. I told you in the very beginning.
Yes, I may be allowed to withdraw, my lord, with liberty to file.
That case and this case is totally
Yes,
different. The facts are different. On that case, there was nothing like absconding or something like that. During the whole investigation period, there was no allegation against him. He was not arrested. In that circumstances, that AB was given to him. This is your case is not like that.
Obliged.
On the prayer of the learned counsel, on the prayer of Mr. MJ Kadir, the learned counsel appearing for the accused applicant, this, the instant AB is dismissed as withdrawn.
With regard to file appropriate.
You can, NBW, you can always challenge there, you can go and challenge it.
Okay. And six.
There's any information you have received? Huh? Information not received? We'll take it up at 2, then we'll wait for some time, let them confirm it, I mean, whether it's this. We'll take it up at 2, you may attend other works, then 2 o'clock you can come.
Well, fair hearing.
The petitioner was arrested on 25/12/2000.
You're filing of objection or what?
Lordship,
Yeah,
in,
objection.
no lordship,
You're not filing anything, no?
Already filed.
Where is that? It's not there.
it has been filed lordship, and here lordship, investigation has not been completed till
No, no, have you filed any objection to this?
lordship.
Where is that?
This
I have not
yeah,
received it. It's not on record. It's not on record. It's not on record.
lordship.
What is to be done?
Lordship may take it up at 2, Lordship.
Lordship.
May file and report calling it.
You bring it on record. I mean, how will you bring it on record less like that? When you file it, you should confirm the whether this is there in the record or not. In the morning also itself, we can find out from the record.
Extremely sorry, lordship.
No, why need to do this kind of exercises? You should do it. I mean, we have filed it, so whether that is there on record or not, you should check it up. Okay, we'll try to take it up after 2.
May I please, Your Lordship? Here the petitioner was arrested on 24/6/2025. As on date, Lordship, he has completed 7 months and 25 days. In this present case, my lord, charge sheet was submitted on 23/7/2025. And thereafter, my lord, charges were framed on 17/10/2025.
23/7/2025 charge sheet file.
Charge sheet filed.
Then?
Then charges were framed on 17/10/2025. I had approached the learned court below for bail. My bail was rejected on 17/10/2025.
Bill rejected on?
17/10/2025.
On the same date?
Same date, my lord. Considering the fact that Lordship charges are framed, so bail was rejected. Lordship may kindly come to the FIR, page number 16.
One second, one second.
11 pages I have flag mark, Lordship, may kindly see that. Regarding 183 statement. Also and the very important is the medical report.
My lord, may kindly peruse the FIR and 183 statement as well as medical. I'm relying only on these 3 documents as because Lordship, allegation of rape is there, Lordship, my scope of submission would be very limited. Page number 16 is the FIR. 183 select, my lord.
How old is the girl?
47 years.
47.
My lord, may kindly come to the medical report that I have annexed also, lordship, and it is there with the.
The medical I have seen, what do you have to say, submit on that?
Yes, lordship. Final.
183, where?
No, see,
183 said,
180 is there, man. It is there. I have flag mark. One eighty statement, madam, they are medically supported by 183. Madam.
okay, okay, what do you have to submit? What do you have to submit?
But here, lordship, the medical of the victim was conducted on 23/6/2000.
Same date.
Same date, lordship. And in the final opinion part, lordship, there are no signs of suggestive so and so income.
Yeah, opinion doesn't matter. That the
And
report is there.
Another thing is that, lordship, here, lordship, charge sheet has already been submitted, lordship, and I'm behind the bar, lordship, since 7 months and 25 days, lordship. I will face the trial, lordship, may kindly release me on any.
No, I mean, no victim has been examined, no informant is, I mean,
No.
Yeah,
not yet
the
examined.
age of the victim is
The heard,
47 years.
maybe, heard Mr. M. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. MP Goswami, the learned additional PP. An FIR dated 23/6/2025 lodged by the victim woman alleging rape on the victim, rape on the informant while she was going to her work as a ASA worker. It was alleged that while going, she met the accused person on the way. An accused person took her to a secluded place and thereafter raped her. On receipt of the FIR, the Nilam Bazar Police Case Station case number 86/2025 was registered, which after investigation was charge sheeted against the accused and subsequently charge was framed. Against the accused applicant accused applicant in sessions case number 197/2025, which is pending before the learned additional session judge, FTC Sri Bhumi. Full stop. The charges have been framed against the accused applicant under section 126 in bracket 2 stroke 127 in bracket 2 stroke 74 stroke 75 64. However, the prosecution evidence has not started as yet. Full stop. The learned counsel appearing to the accused applicant submits that the accused applicant was arrested long time back, and he has already spent more than 7 months and 25 days behind the bars. He further submits that medical report of the accused, medical report of the informant does not indicate any possible sexual act by the accused applicant. He further submits that since how many witnesses are there?
7 witnesses are here.
He submits that since there are 7 witnesses listed in the charge sheet and none has been examined till date, the whole trial procedure will take a considerable time, taking into account the aforesaid facts. The accused applicant should be granted bail. The accused, the learned APB, on the other hand, submits that none of the PWs, including the very important informant, is yet to be examined, and the release of the accused applicant at this stage may harm the whole trial process, may influence the whole trial process adversely. This court has heard the submission made by the accused, made by the counsel appearing for the respective parties, and taking the whole facts into entirety and taking into account that none of the PWs has yet to be examined, is of the considered opinion that that at this stage the bail should not be granted to the accused applicant. According the bail application is rejected.
Yeah. Okay.
My lord, in this case, my lord, the only plea that I am taking is that, my lord, no 48 notice admittedly has been issued to the relatives. Even I have verified the scan copy of the record which has been called, my lord. Even in the records, my lord, there is no 48 notice. And the petitioner is behind the bar for last 1 year and 4 months. And out of 10 witnesses, till date, none of the witness has been examined.
Lordship, this matter may be fixed tomorrow, Lordship. NCB is reflected, Lordship. This is DRI matter, Lordship. NCB is reflected in the cause list, Lordship. This is DRI matter, Lordship. So, Lordship, we have missed a matter, Lordship.
My lord, the same-
Sorry, I could not
We
understand.
missed the matter, Lordship. NCB is reflected in the cause list, Lordship. This is DRI matter, Lordship.
The same set of counsels were representing both the NCB and the DRI. And the objection was also filed by them, my lord.
No, I mean, like, they have a technically, I mean,
Lordship.
problem with this.
So tomorrow.
Tomorrow, Lordship.
Tomorrow not possible. Monday we'll take it up.
No, my lord, my only predicament is that, my lord.
No, I mean, you said you have a good case, so Monday also you'll get it. Don't worry.
Because they filed the objection, and we was already, we had given them prior information also that this matter is listed.
Monday we'll take it up. Monday. That Mr. Biswas and so and so. No, both the parties are represented. Let the matter be fixed on Monday. Monday come prepared with the,
Lordship.
I mean, don't do, I mean, because his case is listed, you are aware of this, list comes out quite early.
The same set of counsels for both the departments. It's
No,
not that
Lordship,
somebody else, it's only day before yesterday.
The same set, isn't it? You are the same counsel, but why don't you bring the records?
During that time, it was the same set of counsel.
You should bring the records.
Lordship, nowadays we are not appearing in NCB cases. That is why, Lordship.
They're not appearing this.
Hardly.
I think NCBI these days, Mr. Chaudhary appears for NCB.
I'll not argue, my lord, during that relevant period of time, they were.
Maybe they were there, but now council has changed.
This technical, please, my lord.
Now the council has changed. What is to be done? I mean, they are not authorized to argue now. Then what is to be done now?
This is DRI matter there. Anyways, my lord.
Hi, Your Grace.
Monday it will be taken up.
Lordship.
Monday.
Your Lordship, this is the case, Your Lordship, under section 21C, Your Lordship, and I am been barred from last 87 days. Here in the FIR, Your Lordship, if Lordship permit me, it is clearly categorically mentioned about the one team annexer 1, Your Lordship,
Yes.
page 27. This is the FIR.
PML also involved or what?
Yes, the Naka has been done at Sonapur toll gate. And by the accused persons who have been arrested later on at Amingao. So there is no deal with me in my case. And moreover,
No, I cannot understand. I mean, you tell me a little bit.
FIR is there, page 27, Your Lordship, Annexer 1. May I read, Your Lordship?
Page 27.
27,
Mm,
Annexer 1, Your Lordship.
mm.
I would like to
report that at 11 a.m. source information was received by Sri Kalyan Pathak, Additional SP Headquarters, Kamrup STF, that narcotic would be transported from Manipur to Lower Assam district as a renal queued during a bearing number so and so, which was escorting and looking out for a police naka, etc. And in a new Tata Altos without nameplate, it was informed that the carriers were deposited in SRFs, and since they were carrying a huge quantity of narcotics, they would not stop at the police naka, would run over anybody that would stop them. Lordship, thereafter, based on the input team, a team was formed. It was planned to stop the vehicle at the toll booth at Sunapur, Lordship. At 2:30 p.m., the queued vehicle was stopped at the Naka, and the occupants of Visit Day and Biki Mojimba were questioned about the narcotics-laden Altos vehicle. They stated that the Altos was on the way of Borbeta side via Amingao. Accordingly, the police team were alerted, and the said Altos vehicle without number plates was interrogated at Amingao, Your Lordship. Both the vehicles and said 50 soft box packets of heroin weighing about 970 grams without cover have been recovered from the secret chamber located under the Tata Altos vehicle. The two carriers in the Tata Altos via Raju Giri and Bahadur Giri of Nizorapar, Bukajan, Wahidur Ali, and so have been arrested. The two owners escorted who were Renault, namely Abhijit Day and so has been arrested later on. So my humble submission before this, Honorable, that they have been arrested by the Tata Altos without nameplate at Amingao, not at Sunapur, Your Lordship. And so my humble submission is that in this case, if Your Lordship go to the page annexer 2, Your Lordship, it is as annexer 2, they have give the forwarding report. In that forwarding report, it has been mentioned that the conscious possession that recovered have been recovered from that vehicle here, the Tata Altos vehicle, no, not from the renal queue. And because I
So that is a modus operandi nowadays. I mean, one vehicle will go and like one vehicle will follow, and one vehicle, the other occupants will say, no, nothing has been recovered from my vehicle.
No, that
And
is,
he will keep a track on where the vehicle is going, where the vehicle is not going.
no, that is not my case, Your Lordship. My case is in hand is that they have said that in the FI that escorting has been take place in. Escorting, police escort is also there in subsequently. If there any escort in my part, then it is to be defined as a aspect. And if Lordship permit me to go to the Caesar list, Your Lordship.
No, you show me that forwarding report.
Forwarding report at Annexer, Your Lordship. There is a two forwarding report.
Hmm.
One at Annexer 2,
Annexer 2.
Lordship. Page 28, Your Lordship. May I read, Your Lordship?
Yes.
With reference to the subject matter above.
No, don't read all the things. Read.
Only the brief of the case of Your Lordship. Everything has been mentioned that cut and paste only, Your Lordship. That
Okay.
is nothing else different. Only the arrest has been done.
Hmm.
Then thereafter, they have said that, I just go to one point, Your Lordship. Brief of the case, Your Lordship. Both the vehicles were sacked with 50 shops and so, and Tata Good. The two owners, this is.
Mr. Borua, see, whatever the statements are there, I mean.
Yes, madam. Lordship may kindly, madam. Peruse, madam, the forward.
And also the next another forwarding report is at a 20 page.
See, Mr. On your information, the Tata Altos vehicle was recovered, right? On your information. So how can you deny that you were not linked? We are not aware, you didn't have knowledge?
Lordship, this is a police confess 42.
What police confession? You have stated that Tata Altos vehicle is carrying that, narcotic contrabands. And on your information, the police went there and like they seized it. Now you say that like, I don't know anything.
Lordship, this is not a case in hand because if it is.
No, what is the case in hand? No, you tell me what is the case in hand.
Lordship, permit me to go.
No, what is there in the FIR? What is the allegation? Allegation is that you have been escorting the vehicle, then the other vehicle went somewhere and you went somewhere, then you have been stopped. Then when you have been asked, then where the other vehicle has gone, then you said this vehicle has gone to Borbeta side and that vehicle is carrying narcotics. Then police went there and police found that vehicle and seized the contrabands from there. This is the fact, right?
Lordship,
Then if it is the fact, now how can you say that you don't have knowledge?
Lordship, this police vehicle who is have been seized, it is by Amingam police station, not by Sunapur police station.
So what?
So my humble submission is that if it is with possession in my hand, then that is a defined issue. So page annexer 4, Your Lordship, page 24, if Lordship permit me, Your Lordship. Annexer 4, Your Lordship. one car vehicle so and so.
One second, one second, one second. So you're behind the bars for how many days?
Lordship, I was in there for 87 days, Your Lordship. I'm totally no way connected in this.
No, your bail is rejected. Heard Mr. So and so the learned counsel appearing for the accused applicant also heard Mr. R.J. Borua, the learned APP for the state. This is an application under so and so. Then you write one on 23 an FIR was lost on 23/11/2025. By one SI in bracket P Dinesh Chotia of Amingaon outpost, alleging that on the basis of some secret information regarding carrying of narcotic substances by two suspect persons, you were driving a vehicle. I mean, how come motorcycle has come? Motorcycle was there. And you see page 4, what have you written? Page 4, paragraph 3. In the middle portion,
Lordship.
soap boxes on a motorcycle without
that is-
registration.
No, it should be vehicle. It should be not a vehicle, motorcycle. It should be vehicle, Your Lordship. I may be typological error, Your Lordship.
Right, on receipt of secret information of transportation of narcotics from Manipur to Lower Assam district in a vehicle with registration number AS01FB 7240. And in a Tata Eltros vehicle, the police team put a Naka the police tried to stop the vehicle at tool boat at Sonapur. On questioning the occupants of the aforesaid vehicle about the narcotics laden Eltros vehicle, they intimated that the Eltros vehicle was on its way to Borpeta side via Amingaon. Accordingly, the police teams alerted accordingly the trap was made and the Eltros vehicle without a number plate was intercepted in Amingaon. On search of both the vehicles, 50 soap boxes of heroin weighing 970 grams have been recovered from secret chambers located under the Tata Eltros vehicle. the two owners, the two occupants of the Renault Kwid vehicle. That is the accused applicants were arrested from the spot. After investigation, the police forwarded, after investigation, don't write after investigation, you write, since then the accused applicants are behind the bars. Full stop. The learned counsel appearing for the accused applicant submits that nothing has been recovered from the conscious position of the accused applicants. And accused applicants have been arrested only on the basis of suspicion. Full stop. He further submits that since the accused applicants have already spent 87 days behind the bars, the accused applicants should be allowed to go on bail at this stage. Case diary in the instant case has been produced before this court, and this court has produced the materials brought before the court, as well as heard the submissions made by the counsel appearing for the respective parties. Having found prima facie material against the accused applicants of their involvement in the offense so narrated in the FIR, this court is not inclined to give any relief of bail to the accused applicants at this stage. Accordingly, the instant bail application is dismissed. Just come back in 5 minutes. Case diary not received, both parties are represented, case diary not received, did the matter be listed on
26 months.
on 26. 26, lot of matters have been fixed already, 25th.
All the co-work is already released and.
Let the case diary come,
So 25th.
25th. 25th.
Allowed to withdraw this petition, the petition or.
You want to withdraw? Okay. On the prayer of the learned counsel, if learned counsel appearing for the accused applicant, for withdrawal of the matter is dismissed on withdrawal.
18.
May please, your lordships. In this case, your lordships, the petitioner was arrested on 9/9/2025 in connection with NDPS case, your lordship, which is pending PCL just Nolbari. As on today, 163 days, more than 5 months has been detained in jail. So first you turn your.
Commercial quantity.
No, so intermediate quantity, your lordship. That 17, page number 17, FIR page number 17. 6 continuous suspected drugs were recovered from the possession, 8.04 gram, and registered under section of bottom part 21B 29 of NDPS Act. And lordships, page number 20. Turn to the page number 20. Earlier, FIR was lost, and accordingly he was released on bail, on default bail. That is page number 21.
Then what happened?
Page number 21.
And then what happened?
Then for the, your lordship, accordingly, I was submitted charge sheet, including 5 witnesses, and that you find 28 page onwards 29, 5 witnesses, 4 witnesses has already been examined, and thereafter, your lordships, this present accused petitioner falsely implicated in another case that you find page number 40 in short February PS case regarding NDPR, and at the moment he was not appear this present case that is pending in Nalbari district, special judge. And this case, he was arrested. Accordingly, he was not present. Trial was going on, he was regularly appear in NDPS case that is pending in special judge Nalbari. But another case is implicated that you acquitted, that part you lordships 59 page.
No, 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 I mean, in the instant case, he was arrested and he was behind the bars for
163 days.
He's 163. What happened earlier?
And
Now, you have been given a bail.
bail, yes.
Then
Thereafter, IO was submitted charge sheet.
charge is submitted that.
Charge sheet.
Yes.
Thereafter, he was regularly appear
Hmm.
this present case.
Hmm.
But his another case, he was
Hmm. He
arrested.
was implicated, he was arrested.
Arrested.
Yes.
Thereafter, that case, he was acquitted
He was acquitted.
from special judge Borpeta.
Okay.
Thereafter, he was not appear regularly in the Nalbari district.
Why?
That is, he was arrested in another case that Borpeta district
He was inside the,
in jail.
inside the jail during that
Jail,
period.
jail, yes.
Then,
Thereafter, custody warrant was issued that you find page number 61. Annex 7. Issue production warrant of the accused Samsud generally from district jail Borpeta, send a copy to the order landed CGM Borpeta. And another, you paint page 62, your lordships kindly see.
12/6 and 2024.
Yes.
12/6/2024 order and then 9/9.
Yes, 9/9/2025, physically produced.
Hmm.
On the day of 9/9/2025, he's
Hmm.
remaining jail.
Hmm.
And on that day, on behalf of the
His bail was rejected.
rejected on the
Hmm.
nature of gravity.
Hmm.
But here in this case, your lordship, 163 days.
Hmm.
And 4 witnesses has already been examined out of 5 witnesses. Only forensic and intermediate quantity. So
So, Mr. Borua,
any condition may be imposed, he will regularly appear.
My lord, the question is that, my lord, in this case, my lord, earlier he was granted default bail, my lord.
Yes.
After that, my lord, he was arrested in another case, my lord.
he was behind the bars.
He was behind the bar in connection to another case.
Another case.
Not in this case, my lord.
Correct. So he was behind the bars, so he could not appear.
Appear,
He could
yes.
appear. Whether, my lord, the council has taken steps on his behalf or not.
So-
And for what reason, my lord, he has been, production warrant has to be
So
issued.
now in this case, already intermediate quantity and he has already spent 163 days.
Yes.
So, I mean, and all the, important PWs are already examined.
Examined.
I mean, only FSL.
Only FSL is required.
is pending.
So at this stage, what is to be done? Let him,
Any
Question is that, my
I will
lord,
regularly appear.
but the question is the production warrant was issued because he is not appearing and neither is counsel. for
but because
taking
at
steps.
that point of time, he was in jail.
Yes,
Yes.
but that has to be applied, my lord, to the court below, my lord, where his trial is going on, my lord.
No,
Yes,
that
There
is
is no
true.
fault of
Yes.
the trial court, my lord.
He was already produced, in that case.
To production warrant, my lord.
He was produced.
Yes. 12/6/2025. Recording has regularly appeared. As per-
When is the next date?
Next date, your lordships,
My lord, Page 64, my lord.
next date, your lordship,
It is 16/1. What happened on
9 to
16?
2026.
16/1 to 2026. What happened on 16/1/2026?
That is, my lord, the report is also not available, my lord.
What's he been?
The
Scan
16,
copy is there.
16/1, what happened? 16/1, I don't think it will be here.
As per party concern, your lordships, you regularly appear and the step was taken by his engaged counsel. 163. PCL. NDPS.
Production warrant was issued on
You done your lordships. 12/6/2024.
12/6.
Yes. Annex 7.
So after it, he has been regularly, he has been,
Under occasion, he was regularly appear. So party concern, your lordship.
no, 12, after 12/6,
Yes. Fixed on your lordships 9/4/2026. As per e-court. Any condition may be imposed. 4 witnesses has already been examined. Only forensic, except forensic. Your lordships, as per e-court, your lordships, 16/1/2026, may I read your lordships. Accused Shamsuddin Ali is produced from district jail, Nolbari. Accused Bitipon Kakuti, another accused, is absent with step. Seen the petition number such and size filed by the engaged counsel, showing cause of absence of the accused due to ailment. Care is allowed. Witnesses are absent. Summons have not returned. Issue summons witnesses. Sandan Das, this is official expert. His evidence may be recorded through video conference. Remand back. Accused Shamsuddin Ali to jail hazard till 9/4/2026. This is the 16/1/2026 last order. And matter will fix 9/4/2026. Length of detention kindly be considered. In fact, he will appear regularly a lot. Any condition may be imposed.
What was the quantity?
Quantity 8.04 gram.
Intermediate.
Intermediate, your lords.
1.08 grams. Yes, Mr. Borua.
Length of detention as
Only madam by Habut madam, he is also implicated in other cases, madam.
okay.
Other cases, but trial is going on, madam.
The one he has been already acquitted.
One case acquitted, another case trial is pending, my lord, wherein he was arrested, my lord. In that, my lord, other case, my lord. Mukalma, in connection with Mukalma case number 307, my lord.
That case he was released on bail.
Now, my lord, he has again been arrested only because, my lord, probably he has not appeared, my lord.
He did not appear because he was in jail at that
His
time.
counsel should have taken steps, my lord.
Hmm?
His counsel should have taken steps.
Correct, but like facts are like that. Facts are like that. Let him go. I mean, he'll only the forensic is required. An intermediate quantity.
Yes, lords.
Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borua, learned APV for the state. The case relates to recovery of 8.4 grams of suspected brown sugar from the accused applicant. Full stop. Police registered Mokalmo case number 623 stroke 21 under section 21 small b stroke 29 of NDPS Act, wherein the trial has wherein the trial is still going on.
Before special judge.
Going on before the special
Special
judge
judge Nalbari.
Nalbari. Special judge
NDPS case number
Nalbari. In NDPS case number
43/21.
43/21. It is the learned counsel appearing the accused applicant submits that all the PWs have already been examined, except
Except what?
except the forensic
Forensic.
except the forensic expert, and he has already been jailed for last 163 days. He submits that the remaining part of the he submits that taking into account this his detention, as well as the fact that all important witnesses have already been examined, further detention of the accused applicant in custody is not required in the case. Therefore, he submits that the accused applicant should be granted bail at this stage. The learned APP, Mr. Ajay Burwa, on the other hand, submits that he is implicated in other NDPS cases also, and he is an habitual offender. In view of the aforesaid, he should not be granted.
As on that, out of 5 witnesses, 4 have already been examined.
Only forensic person is there.
They have implicated also.
Hmm? Yeah?
Other witnesses have implicated.
Yeah, correct. That is there. That trial will see that.
My lord.
Therefore, he should not be granted bail at this stage. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties, as well as perused the case diary, perused the trial court record that has been placed for this court. Taking the entire facts, taking into account the fact that the accused applicant has already spent 163 days behind the bars for allegation of recovery of an intermediate quantity of brown sugar, and as well as that all important PWs have already been examined, is of the considered opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of ₹50,000 with a surety of like nature to the satisfaction of the special judge NDPS Nalbari, subject to the following conditions: that the accused applicant shall appear before the trial court as and when required, that the accused applicant shall not try to influence any witness, that in view of the aforesaid directions, the instant bail application is disposed of as allowed.
In this case, my lord, notice is not served, my lord.
The office note, both sides are represented as per the office note dated 17/2/2026. Though the scan copy of scan copy of the trial court record has been received, but no report as to service of notice on the respondent number 2. Let the matter be fixed. Let the matter be fixed on 27th.
My lord, item
20 and 21. 21 also may be taken up together, my lord.
2021, my lord, and another item 44, my lord. We have I'm just praying for my 1 day's accommodation, my lord. Let the matter come up tomorrow, my lord. We have to go to the case diary, my lord.
So tomorrow it will be difficult, Mr. Amma. We have already intimated Mr. Parasar that tomorrow it will be
Just,
difficult.
Lordship, kindly go through just
2
once,
PM,
my lord,
2 PM.
then whether at 2 PM, my lord,
No, no.
whether it
tomorrow
is
2 PM.
necessary, my lord, to
Tomorrow
go through the case diary. My lord, four people has been apprehended with a some amount of cash, my lord, along with the checks, my lord. The initial case of the police that we are going to USTM, the moment name of the USTM came up, that these people are going to USTM for a particular scene. So when the USTM name came up, then they have come out with a new case, my lord, that this money may be from terrorist funding, my lord. That is the terrorist, but these people are not terrorists. Nowhere they have any terrorist link, nothing. Only the apprehension on that day and
Mr. Borua, after 2 o'clock.
No, not today, my lord.
No, today we'll finish it
We
off.
will
I
take-
mean,
we will go to the case diary.
only
you
this
go through
piece-
case
and
diary.
on that day, my lord, there is
I
a
mean, you have 3 councils, 1 council, you go through it. But tomorrow it will be difficult. That's why I intimated. I mean, many matters are there. Yesterday, a lot
Is
of
there
matters are
any
left over.
terrorist link, my lord?
So those matters
would
it
have
will be
not-
taken up. You will take it up at 2:30?
Only, my lord, 1 day accommodation.
2:30 will take it up. 2:30,
My-
you just go through it, 2:30 will take it up.
Obliged.
2:30 will take it up.
20. Is it to
Yes.
The petitioner was arrested on 22nd/7/2025 and since then is behind the bars. Lordship, no prosecution witness has been examined till date.
Hmm?
No prosecution witness has been examined till date. And
What is the offense?
366 of IPC and Section 9 of Protection of Child Marriage Act. The allegation was that the kidnapped girl was kept in the house of the accused.
The minor daughter,
petitioner.
Yes, my lord.
minor girl.
Minor girl, my lord.
But the accused is not, in the allegation, it is not stated that he is anyways related in the kidnapping. It was only that the girl was kept in his home, concealed in his home.
Accused is,
Rupa Kalita.
accused is Mr. Dubo Kolita,
Rupa
okay.
Kalita.
FIR PS Mukherjee alleged to have taken away his daughter and left her at residence of Dubo Kolita. His body is in a similar manner. Prison was kept her in accused name. Even that the incident same nature. What is the allegation?
My lord, allegation is that, my lord, regarding 366A, my lord, without the consent of the lawful guardianship, he was taken kidnapping, my lord. And in 164 also, my lord, but she says that, my lord, he voluntarily left, my lord. That is what.
He voluntarily left.
In 164, she says. First, may kindly see the verse. But whether, my lord, that would, my lord.
When I see, I mean, it was the allegation in the FIR. You just see the FIR.
Lord.
There is nothing in the allegation.
Yes, but my lord,
How many days you were behind the bar?
Almost 7 months. Lordship.
7 months.
FIR, my lord, in the FIR, my lord, it was, my lord, alleged that, my lord, before also.
Before also, but
Yes.
why FIR was not filed then?
Yes,
Why
my lord.
complaint was not raised?
Yes, that is it. That is why,
No-
my lord,
nothing- nothing
again,
is
my
there.
lord, on suspicion, the FIR filed. But it came to be true that the girl is actually with the person, my lord.
With the person.
Yes,
And what happened after? Is there any other things came out?
Two things, my lord. Lordship, may kindly, I have seen the
Now,
reflect back, my lord.
now it is which stage?
Evidence.
Evidence stage, my lord.
Evidence stage.
Evidence stage, my lord. Only thing, my lord, that she is a minor and her statement is not yet recorded.
Hmm? What is there exactly in?
If your lordships goes to 164, it will be clear.
366, whether it will be applicable here.
Yes, because the minor part will come, the other things, my lord. will
No,
be
minor
subject-
part is there, but there is no allegation of other, I mean, any sexual
Yes.
exploitation or whatever.
Subject to trial, or that would be, my lord.
But as far as this, I mean, apparently there is no, I mean, allegation of 166 also. I mean,
And section 9 of, my lord, prevention of child marriage, that will be. Because she stated that she has been married to the accused.
P66 prima facie is not not applicable to this case. Maybe that that child marriage may be applicable. But what is the stage now? I mean,
It's a stage of evidence, my lord.
stage of evidence. He's already behind the bars for
It's almost
7 months. Let him go. I mean, there's nothing in this case. Heard MS?
Mayuri Gogoi.
Mori?
Gogoi.
Mori Gogo, M. Gogoi, the learned counsel appearing for the accused applicant, also heard Mr. Goswami, the learned APE for the state. This is an application under so and so. An FIR was lodged on 10/12/2018 by one Sri Lalita Nath, accusing within Nath alleging that one Mokab Ali had kidnapped his daughter and thereafter left her in the house of Dhruva Kalita, the present accused applicant. It was also suspected that his daughter was earlier also taken to the house of Dhruva Kalita, which is in a different village. Full stop. After receipt of the FIR, police registered Mukalmo police station case number 453/2018 under section 366A IPC. But it was registered under 366 IPC initially. But charge was framed under 366A.
Because see, the date of birth was found to be 24/1/2023.
But
2003, my lord.
correct, but 366 is may be applicable in this case
Yes.
without making any
Yes.
comment on, I mean, without evaluating lot many other things. But 366A, I mean, is little bit different.
Yes.
It is taking minor girl for exploiting her. Exploiting her. This is 366A may not be applicable
For
in this case.
begging purpose.
Okay, right, see 366 IPC. Read with section 9 of the Protection of Child Marriage Act 2006. After investigation, police filed Charge sheet. Have we annexed the charge sheet? No.
In the case of 366, as your lordship pointed out,
The police filed charge sheet and thereafter charge was framed against the accused applicant under 366A IPC read with section 9 of the Prohibition of Child Marriage Act. Full stop. Full stop. The case is pending before the court of the district and session judge Nalbari in the evidence stage. The learned counsel appearing for the accused applicant submits that the accused applicant is not involved in inducing the victim girl for any sexual exploitation, and therefore section 366A is not applicable. 66A of Indian Penal Code is not applicable in the instant case, and charge has been wrongly framed against the accused applicant. She further submits that since the accused applicant has already spent 7 months inside the jail, inside the jail, he should be allowed to go on bail at this stage. The learned APP, on the other hand, opposes the bail at this stage. At this stage, full stop. Taking into account the whole facts of the case, as well as hearing, as well as after perusal of the trial court record, this court is of the considered opinion that at this stage the accused applicant should be granted bail. Full stop. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of rupees 20,000 with a severity of like nature, subject to the following conditions. You put those three normal conditions. Sir. It's a trial court, so cooperation to trial and all these things, right? And in view of the aforesaid direction, the instant bail application is disposed of as well.
47.
47. Well, 47 minute CD we have not received, madam. Kindly.
The 47 matter was a part heard. Only thing was that, I mean, Mr. Borua was supposed to give me the status.
Let him come then, madam. I am not aware, madam.
Only the status of
Yes,
investigation.
he's coming.
Okay, okay.
Ma'am,
We'll pass it off time.
No, sir. No.
23.
None appears.
None appeared when the matter was called for. None appeared for the accused applicant when the matter was called for. Let the matter be fixed. Let the matter be fixed. 23.
47. Yeah.
Let the matter fixed on 23rd. 47 you have received? Yes, 47, we can probably close it. 47. Your counsel was supposed to appear from the VC?
Is an online.
Yes, Mr. Borua, what is there?
This honorable court, there are two queries, my lord. One is the whether, my lord, during this period, my lord, this accused person was interrogated in the, my lord, in the jail or not, my lord. This is the first question, my lord. And second query was that, my lord, what is the progress of the investigation?
Status.
So the IO investigative officer has informed me over telephone, my lord, that investigating officer has informed me over telephone that, my lord, during my lord, police custody, my lord, he was interrogated, my lord. But now in the jail custody, he has not been interrogated, my lord. And secondly, my lord, during the course of the investigation, my lord,
Okay, well,
So-
the first is that in police custody, he was interrogated.
interrogated. Because he was given, I think, my lord, 4 days, my lord, police remand, my lord. So during that period, my lord, he was interrogated.
Interrogated, but in jail custody, no interrogation.
Not interrogated, my lord.
No interrogation, and now status?
Now, my lord, status of the case is that, my lord, since there are other affairs also, my lord, against this person, my lord. So he has asked this, my lord, other informant, my lord, to provide all the information, my lord, that how much money they have to, my lord, they have to get from the, my lord, accused person, my lord.
That is already there in the FIS.
No, it is FIR, my lord, but is there any statement, my lord, or what, if there are any?
But their statements have not been recorded till now.
Not recorded, my lord. So, my lord, IO is also, my lord, at present, he is on leave, my lord. So after resuming on duty, my lord, he will again, my lord, start the investigation.
So that means like no statements of the complainants have been recorded till now.
No, other
Other than this Sharma, Biswajit Sharma, no statements of the complainants have been recorded till now.
Till now, my lord. Till now, my lord, there are 3 witnesses examined, my lord. Biswajit Sharma, then, my lord,
No
Shiva
statement,
Hardalka,
no statement of other witnesses except the other complainants.
Already in the forwarding reports, 5 statements are there.
One second, complainants except
Shiva Hardalka,
except Siba Harlalka,
Biswajit Sharma,
Biswajit Sharma,
and another witness, my lord, his name is
Biswajit Sharma, no other, no, I mean,
the informant of the, his name is Rabakanta Dotto, my lord.
Revakanta Dutta. So except these 3 persons, statements of other complainants have not been recorded.
Recorded as on that matter while the CD was forwarded to us, my lord.
Well, till now, we have not CDA.
Yes.
Till date,
till
we
now,
are asking.
Till now.
So so Mr. Borua, it seems after his custody, nothing has progressed.
In 70 days, my lord, only 3
No,
statements.
progress, my lord.
And today,
progress-
today, how many days?
52 days, my lord.
52 days.
FIR was also 15-12, my lord, so almost 70 days investigation is going on. Only 3 statements have been recorded as per the IOM.
Yes. So this is what we wanted, like how the investigation is going on. So,
He has asked the informant of the other FIR, my lord, to provide documents, my lord.
no, correct.
Regarding that,
I mean, so investigation is going on, as per you, but like no statements not recorded. I mean, no, his further interrogation was also not done.
Not done in jail, my lord.
My lord, and order dated 2-1, my lord. When magistrate allowed the IO to interrogate him in jail for 4 days, my lord. That was also not done.
Was there any order?
Yes, well, order dated, order is at page 62, my lord. Order dated 2-1.
Order dated
2-1-26, my lord.
2/1/26,
26, my lord.
page
Page 62 it starts.
62. Magistrate allowed him,
He
allowed the
IO
police
to interrogate me in
police to-
jail, my lord.
interrogate in jail.
Yes, but page 64, IO concerned is hereby permitted to investigate the accused so-and-so within the premises of Central Jail, Gauhati, every day for a maximum of 6 hours per day till the next remand date. So for 14 days, they were granted time. my lord. Page 64, last paragraph. my lord. That was also not done because possibly not required.
Page 64.
64, yes, operative part, last paragraph. my lord.
Okay. So, but he's not been interrogated
Not-
in spite of having this order.
Yes,
14 days.
for 14 days. my lord.
14 days it was allowed.
One entire remand my lord,
Entire month. I mean, for 6 hours per day.
per day. my lord.
Okay, heard Mr. N. Mahajan, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Borua, learned APP for the state, as well as Mr. K. Gupta for the informant. Full stop. wide, the order dated 17/2/2026, this court directed the learned APP to provide the status of the investigation in the instant matter. Accordingly, though no report, no documentary report has been submitted before this court, but it was intimated that he had instructions. He had certain instructions for the investigating officer, and the same has been submitted before this court. Full stop. He submitted that in the jail, though the accused applicant was interrogated in the police custody during the initial police remand. However, no interrogation of the accused applicant took place in the jail custody. He further submits that the investigation is still going on, and except Shiv Harlalka, Biswajit Sharma, in bracket informant, and one Revakanta Datta. The statements of other complainants are yet to be recorded. Full stop. Sharma. Full stop. The hearing is already concluded. Judgment and order is reserved.
Also, we are submitting our written submission.
Written submission. Mr. K. Gupta, the learned counsel, appearing for the informant, has submitted a copy of written submission before this court, which is kept on record. Okay. Reserving it, will pass the order, I mean, as soon as possible. Let's see. Have you prepared any note? No, you haven't prepared any.
Still preparing.
Huh?
I've not prepared. It's not
Okay.
finished completely.
If you want, you can place it,
I will place it today
you
before
can give it to the court.
Yes, sir.
My lord, can I just request if the petitioner is filing, I appear on behalf of Mr. Sehgal, my lord. If the petitioner is going to be filing any document or note, my lord, it can be served to Mr.
That has been
Gupta.
served already. That has already been, that will be served if they file it.
Grateful.
If you file something, then you give a copy. That will be done. We have recorded
Grateful.
his name already.
Grateful.
We are keeping it reserved, we'll pass the order.
Grateful, my lord. Grateful.
Obliged, highly obliged.
24, my lord. I am on interim for last 1 year, my lord. And I have also appeared.
Interim for last 1 year.
Yes, my lord, last
Case-
interim was
ca-
granted in
Yes.
12/3/2025.
CD received now.
Yes, CD received, my lord.
Interim was granted on
12/3/2025.
Yes, what was the matter?
Matter, my lord, there is an allegation by one widow that she was enticed by some of the accused to make a false claim of insurance on the name of her husband, man.
Entice her to make a false insurance,
In the name of her dead husband.
dead husband. Okay,
That is the allegation, my lord.
okay. Then see, you are in interim. Okay, what is there?
Yes, my lord, yes, there, he has appeared, my lord, but my lord, he is the prime person, my lord, accused, my lord. Who,
But why you took 1 year to
Yes,
get,
yes,
I
perhaps,
mean,
my lord,
get the case
I
there?
have seen, my lord, that there is up to the CD once came also, my lord. From last June also it came. It was sent for updation several times, my lord, for taking the investigation ahead, my lord. So at this stage, my
The
lord,
main accused has granted bail, my lord. already.
what,
Main accused, who is the main accused?
Nobin Rabha, my lord.
Allegation was against him.
him.
Where is the FIR?
FIR at page 16, my lord. Initial part is not very important, my lord.
So, but you have been named also.
I've been named also,
Hmm.
and the one more accused, and the basically, my lord, the allegation against one person, my lord, one government village headman, my lord, who enticed her by convincing her, page 17, my lord, first few lines, that they would help her to get money from insurance company for her husband's death. If she can lie the cause of her husband's death due to
So who is the government registered village headman?
that's not been there, man.
He is the person, no?
No.
Hmm?
Nobin.
We are not the, that is Nobin Rava, man.
Nobin Rabha is the co.
Nobin Rava is the village headman.
Yeah,
He has enticed.
He is the co-accused.
He was granted bail, man.
Okay. Let him go. Let him.
Before taking a lordship's decision, my lord, just if your lordships kindly hear me, my lord, just for 2 minutes, my lord. What I have found from the so far investigation is my progress. Nobin Rabha is only a, my lord, he is only a, my lord, pony, my lord. Main, my lord, entire conspiracy is held by, my lord, this petitioner as per the CD, my lord. He is an agent of Reliance.
No, I mean, that I understood. I mean, but only thing is that the court is only concerned with one thing, that like 1 year back interim order was
Yes,
passed.
that,
Now he has been appearing before before.
he appeared once, my
He
lord.
he has appeared once, and if you require, he will appear.
Yes.
Then in that circumstances, is there any need of any custodial detention?
Yes, my need. Why I am saying need, my lord? My lord, just may kindly hear me, my lord.
Tell me
yes,
one thing.
why-
In custodial detention, you will bring out certain other
Yes,
things.
Yes, it might. Yes, my lord.
Then how you tell me
It will be, my
how
lord. May kindly see what.
how you can bring in
My lord.
custodial detention, you will bring in certain other things, and when he appear before you,
Yes, that
I
is
mean,
the
you,
difference, my lord.
what is the
There-
difference?
Today, my lord, I have
No, no,
I
not
got-
today. Not you argue now only. What
Yes.
is the difference?
my
So
lord,
custodial detention,
yes.
you do something else.
I am not saying I am doing something else.
Then what you're saying? I mean, you see, I mean, a person accused,
Right.
he will appear before you, and you need to divulge things from you, from him, right? Now he appears before you by a court's order, and you cannot take out anything from him. But when he is in custody, we can take out from him. Then what measure you take?
May kindly
Now,
see
is there any different measure to take?
I cannot say that I'll take.
No,
the
no,
different
that is
measure,
your
my lord.
submission you are making,
No,
that you need
no,
custodial detention.
Yes, my lord, my lordship, that is what I have gone through one judgment. my
So
lord.
don't waste time. Don't
No,
waste
I'm
time.
not wasting.
Don't
my-
waste time.
my-
Don't
may
waste
kind-
time.
Just your lordship may kindly say what is there against him, my lord.
Hmm.
What he happened, my lord, he took that, the lady and her, my lord, sister, my lord, lady and another, my lord, women, my lord,
Hmm.
to his hotel, my lord.
Hmm.
He paid everything for her, my lord, and for 9 days.
Understood. There are
9 days, my lord, he was
see,
kept, my lord.
Mr. PP.
My lord, now,
Well,
my
no,
lord,
Mr. PP understood there are allegations against
Yes.
him. He may be involved.
Yes.
He may have committed the crime also.
Yes.
But concern of the court is that 1 year has passed.
1 year.
Interim has been given. And till now, I mean, case that you have produced now. Now you are saying that you need him, I mean, you require him in police custody.
Yes.
Huh?
Because
I mean, in compliance of the court order, he has appeared before you.
oh, yes, once he
Then-
appeared, I am not saying he's not.
Then you ask him, tell him to come to you, then he will appear every day.
But what he
You
was-
tell
the
him,
money-
no, listen, you tell him
Yes.
that you appear before me every day. He will appear before you every day.
regarding the materials in the case, my lord. That is it's a grievous offense, my that has to also be taken into account, my lord. If your lordship is granting that. That is what my
Heard
submission
Mr.
is.
A.M. Bora, the learned counsel. Go for the cancellation of this bill.
No, I'll not.
I heard Mr. A.M. Bora, the learned senior counsel, assisted by Mr. B. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. Goswami, the learned APP for the state. This is an application under so and so. Wide and order, wide and order dated 12/3/2025. The accused applicant was granted interim bail. Interim bail, and accordingly, in terms of the aforesaid interim bail, the accused applicant appeared before the investigating officer. Full stop. In the incident matter, the case diary was called for several times. However, the case diary is produced today after almost a year. After almost a year, case diary is produced before this court, and the same is produced Same is perused by this court.
Regarding the, my lord.
Yes, perused by this court, full stop. The learned APP opposes the prayer of bail at this stage, stating that there are various incriminating materials, prima facie incriminating materials against the accused applicant. So at this stage, the accused applicant should not be granted bail, full stop. This court, after considering the submissions made by the counsel appearing for the parties, as well as after perusal of the case record, is of the considered view that at this stage, the interim bail so passed earlier should be made absolute. Accordingly, the interim bail granted by order dated 12/3/2025 is made absolute in the same terms and conditions as stated in the aforesaid order. Accordingly, the instant bail application, AB application, is disposed of.
Obliged.
Return.
Look, my learned friend has taken instruction, my lord. Just after coming, he's coming.
Wait for some time.
The 25 also, man, after some time. They are coming. Man. Fix the material. So it's a
Kuntu? 56 to Kuntu.
26.
Medical report has come.
26, man, search is submitted.
Search is submitted. You go and appear there.
Lordship, interim protection be continued. till
No.
appearance, Lordship.
You go and appear. I mean, ask for appropriate
I mean,
relief.
interim, Lordship.
I understand. I mean, you go there now. Search has been filed in AB application. You go there and ask for appropriate relief. Mr. Boro, I mean, I think in this case, I mean, she can go and he can go and appear
Yes, my lord. Interim can be, but extended till
till the next date of appearance.
That can be extended.
That can be done. Heard Mr. M.
He does, Lordship.
P. Das, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Boro, the learned APP for the state. This is an application under so and so, where in order dated 28/7/2025, the accused applicant was granted interim protection by coordinate bench of this court. Full stop. In terms of the aforesaid, aforesaid order, the accused applicant has appeared before the IO and got his statement recorded. Full stop. How it is submitted that in the instant case, the charge sheet has been filed white charge sheet number.
The charge sheet number 06 of the 2026.
Dated
My lord 16/2/26 months.
16 to 2020, 16 to
26.
26. In view of the aforesaid, it is directed that the interim protection of the accused applicant shall be extended till you have the next date of nothing is there. So how I mean,
It appears, my lord. Whenever someone will be, my lord, he will
extended till he receives his till he he receives his,
Till his appearance before the trial.
till his appearance before the trial
Before the
court.
trial.
But that will, if, that will go on then if summons is not received or something like that.
Normally, madam, that happens, madam, because now charge-sheet, madam, someone will be issued
Hmm.
to him, madam. So till his appearance, madam,
Okay, till his appearance, in terms of the aforesaid direction, the instant bail application is disposed of. AB application is disposed of.
Lots of time.
27.
The 27, my lord, earlier we received the case diary, my lord, but it was again returned for up to date, my lord. Now, up to date CD we have not received.
None appears when the matter was called for the accused applicant. Learned APP submits that updated case diary is yet to be received. Await for the updated case diary. Let the matter be listed on
5-3.
on 5/3.
28.
Well, in this case, CD is able, we have received the case, but it is not updated. Matlab, he interim was granted on 22nd 9/25. But his statement is not available. Matlab, I have talked with the IO to them on morning.
Okay, updated, both parties are represented. Updated CD is yet to be received. Interim order so passed earlier shall continue till the next date of listing.
10th of March, madam.
Let the matter be listed in 10th of March.
29.
29 case. Now, should we ask for the timing? For the timing.
Who is appearing?
No, S. Munir is here.
Huh?
S. Munir.
Time
It's on the
taken
way.
is typical.
30.
Okay.
The scan copy received, my lord. In the, my lord, in this case, my lord, it's a, my lord, case of
Interim was not granted.
No, my lord, because in the search, my lord, she was shown absconder, my lord, petitioner.
Okay.
And there are materials against her, my lord.
Hmm.
And there are two accused persons, my lord. Now the case has been, someone has been issued, my lord. The case is now fixed on 22/4/2026 for appearance.
Someone issued to him, this person also.
My lord, cognizance has already been taken.
May I make my submission?
Hmm.
Lordship, the first thing is that this particular instance, my lordship, she is the accused number 2, the present petitioner, my lord, and her husband got the statutory bail after completing 90 days, my lordship. And both the husband and wife, they are the main accused. Accused number 1 is the husband, and accused number 2 is this present petitioner, my lordship. As because, my lord, they are in the same household, my lordship. As because the petitioner number is the wife, and they will both they will completely cooperate the investigation, my lord. And the medical report already come, my lordship. And medical report, it is though not directly indicated that they have done the offense, my lord. And apart from this, my learned friend said that there are incriminating material against them. My lordship, it is now as because the charge sheet have been filed. So investigation, my lordship, have substantially have been improved, my lordship. So may not be further custodial interrogation for heart may not be necessary, my lord. As because they are the same household, they will completely cooperate with the investigation officer, my lordship.
That is not the question, my lord. Since it is a search case, my lord. Now lordship will have to consider this bail application on merit, my lord. Now, as per the statement of the witnesses, my lord, they have stated, my lord, they have assaulted the victim, my lord.
Who is the victim?
Between the mother-in-law of this, my lord, petitioner, my lord.
Mother-in-law of the petitioner.
Lordship,
And one is son.
Other is arrested his son, my lord.
Son and daughter-in-law, torturing mother-in-law.
Yes, my lord.
Yes, my lord. My lordship, as because shown absconder, because my lordship, I have filed this AB, my lordship, in the month of November, my lordship. The IO concerned authority, IO had never produced any document, my lordship, neither produced any case diary, my lordship. Thereafter, they have filed a charge sheet, my lordship. I would have appeared, I would have completely cooperated the investigation, but they have not produced any document, my lordship, in this court, my
What
lordship.
document?
My lordship, charge sheet, the earlier the case diary, my lordship, they have not produced any case diary. They have, after 6-7 times, my lord, they have filed a charge sheet, my lordship. My only prayer before your lordship, let them cooperate with the investigation, my lord. As because the the charge sheet have been filed with the authorities, my lord. So accused number 1 also got the bail, my lord. Have produced the bail order, page number 36, my lord.
It was a default bail only.
Yes, my
It's not on consideration of materials.
Lordship, maybe give the interim protection, she will appear before the concerned authority. She will appear,
After
my lord.
action, my lord, Lordship will have to consider this bail application on merit, my lord. As part of my lord, materials collected, my lord, there are materials, my lord. That she has also, my lord, caused injury to the, my lord, deceased, my lord.
Lordship, she is being a woman, my lordship, and a small children at home, my lordship. 4 year, 3 year, child at home, my lordship.
And she never cooperated to investigating, getting authority, my lord, during investigation, my lord.
Lordship, she could not able to cooperate because her petition is here absent present, my lordship. I have filed this AB, my lordship, long back, 4-5 months back. This is the first time they have produced some document. They can, I earlier never produced a case diary. 4-5 times your lordship called for. The investigation officer never produced, my lordship. So my humble prayer before your lord, my lordship, she will produce the just for the next hearing appearance. Your lordship may kindly give the interim protection. Thereafter, they will decide, my lord. Just a humble prayer, my lord. She being a lady at the only lady at home, and the small children at home, my lord, and husband and wife, they are the same household. They will cooperate with the investigation, my lordship. Satiated case, my lord.
Let her go.
Substantial
Lady, I mean,
humble prayer, my lord.
heard Mr. So-and-so, the Lorded Counsel appearing to the accused applicant, also heard Mr. R.J. Burwal on a plea for the state. This is an application under so-and-so. The allegation in the FIR dated 10/8/2025 is that the accused applicant, along with her husband, had tortured the mother, tortured her mother-in-law, and mother-in-law, and due to the injuries sustained by the mother-in-law, the mother-in-law expired. And the mother-in-law subsequently expired. Full stop. After investigation in the case, the police has filed the charge sheet. Filed the charge sheet. Where is the charge sheet?
Ashwin, I have better.
Annexed.
In my additional affidavit, I have better Sashit, my lordship. My lordship, page number 19 to 35, my lord.
Filed a charge sheet. Which is the charge sheet? Page?
$29.30, my lord.
Filed a charge sheet by charge sheet number 108/2025 dated 29/11/2025, wherein the
28 is the translated copy, my lord.
wherein the accused applicant has been shown as an absconder. Full stop. The learned counsel appearing for the accused applicant submits that the husband of the accused applicant, who has also been alleged, who has also been named and in the FIR as well as charge sheeted against, has already been granted bail by the learned court. Where is the bail order?
My lordship, 36 page number in my additional affidavit.
granted bail by JMFC.
Yes, my lord.
JMFC Dhubri.
Yes, my lordship.
JMFC Dhubri on 10/11/2025. 25 Land Council submits that the accused applicant being a lady, and since she is willing to cooperate with the trial and appear before the trial as and when required, submits that she should be granted the interim protection. Granted bail under this pre-arrest bail. Full stop. The learned APP, Mr. Ajabolo, on the other hand, submits that there are materials against the accused applicant, and since the charge sheet has been filed, for this stage, the bail should not be granted. This court has produced the trial court record that has been brought before this court, as well as heard submissions made by the council appearing for the respective parties. Full stop. Taking into account of the fact that the accused applicant the accused applicant being a lady. You have a child?
Yes, my lordship.
Being a lady, having a child, and taking into account that the husband has already been granted bail in the instant case, and also in consideration of the fact that the accused applicant is willing to participate in the trial, this court is of the considered opinion that the accused applicant should be given the privilege of pre-arrest bail at this stage. Full stop. Accordingly, it is directed to the Indian event of arrest of the accused applicant by the arresting authority in connection with Narcotics PS case number 84/2025. She shall be enlarged on bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the JFMC Dhubri.
Yes, my lord.
JFMC Dhubri, subject to the following conditions. First, that the accused applicant shall appear before the trial court on the next date fixed. When is the next date?
Next date is not fixed, my lord.
My lord, it's 22/4/2026, my lord.
That is.
The next date fixed, that is 22/4/2026. And then the accused applicant shall appear before the trial court as and when called for. The accused applicant shall not try to harm or something. No? You write that. Shall not try to temper or hamper with the investigation. And in the aforesaid terms, the instant AB application is disposed of as allowed.
Deeply obliged, my lord.
May I please watch more? Case study was called for more.
Did he receive, my lord?
There are all 12 or 14 petitioners. Petitioner number
What is the allegation?
302, my lord. Now 103, my lord. Petitions number 2456 are not named in the FIR, my lord. 2456 and petition number 13 and 14 are juveniles, my lord.
13 and 14 juvenile.
My lord. But they are named in the FIR. Page 16 is the FIR. The three headmen, my lord, Pradip Tokbi, Sarmong Tokbi, and Babu Tokbi, are petitioners 4, 5, and 6. My lord. They were there in a village meeting, my lord. But they are not named as the,
2, 4, 5, 6, you said not named.
they are not named as accused, my lord. 4, 5, 6 are the headmen, my lord. Three headmen, namely so and so. In the said premises, the below mentioned accused person. The below mentioned accused person are the accused persons named in the FIR. They are not named as accused persons. No.
Yeah, they were present.
They are present in the meeting now. They were headmen. Man.
Yes, Mr. Parasar.
Malat 1032 and as well as Malat witch hunting act Malat that is there. And village meeting was called for. The disease with his wife went to the meeting Malat. Subsequently, Malat the villagers Malat assaulted badly and subsequently that person died. But now other witness along with the lady, Malat, wife of the Malat disease. They have take the name of Malat. The other persons are the Horan Tokbi, petition number 1, 7, Sajan Malat, 8, 9, 10, and Malat 12 and 13.
8, 9, 10.
1, petitioner number 1, 7, 8, 9, 10, 12 and 13. These 7 names were taken by the witness as well as the Malat wife of the disease and others Malat there. But
wife of the deceased?
Yes, wife of the deceased. She was also present in the meeting. She along with her husband went to the spot.
No, wife of the disease also involved.
No.
Then?
He took the name Malat.
Wife of the disease has taken the name.
Yes,
Name of 1, 7, 8, 9, 10, 12, 13.
Yes. Others, Malat, other persons are, but all are not identified, Malat. There are villagers, maybe Malat, but their names were specifically taken, Malat.
But it's a case of, what is this? This a disease, kind of a social disease. What is to be done in this kind
Malat,
of case?
but this is AB, Malat. This is AB. Malat, one person lost his life, Malat. But anticipatory bail, Malat, for these persons, Malat, where Malat directly took the name by the witnesses, Malat. Even the wife of the disease, Malat. Other persons, if Malat, others were there, Malat, but others were not identified by the witnesses. So, Malat, I am not on other others, Malat, because Malat, it is not specific. But specific name taken by petition number 1, 7, 8, 9, 10, 12 and 13, Malat. Against this person.
And 13 and 14 are juveniles.
13 and 14 juveniles.
13 I'll pray for Mala because they're juvenile.
15 years and 14 years, yes.
13 and 14, there is no point keeping them as juveniles.
But 12, other person, 6%, out of 14, 6% name, on the benefit of juvenile, to 13, but other persons, specific names are there.
The person is not named, may be considered.
And as per the postmortem report, death was due to combined effect of coma and hemorrhage, shock as a result of injuries sustained over head, throat, abdomen, etc. All injuries were antemortem caused by blunt force impact, by lathi and all this, assaulted by the villagers.
Two, 3, 4, 5, 6, 11, 13 and 14 I'll pray for Mala.
Against these persons, against 2, 3, 4, 5, 6, 11, and 14. I have no objection because no specific fund. And 13, Heard
Mr. N. Mahajan, the learned counsel appearing for the accused applicants. Also heard Mr. K. K. Parasar, the learned APP for the state. This is an application under so and so. An FIR was lodged on 372025, alleging before the OC, the Mocha police station, alleging that on 362025, a public meeting was held at about 8 p.m. wherein the informant as well as her husband were also present. It was alleged that after reaching the field, reaching the playground wherein the meeting was conducted, that the son of one Mensing Kramsa of the same village suffered from typhoid disease and the son, namely Mirlong Krama, informed before the public that due to some black magic done by the informant's husband, he has suffered from such disease. It was alleged that in the aforesaid meeting, village headmen, 3 village headmen were also present. On such intimation by the aforesaid Mirlong Krama, who was suffering from typhoid, the accused applicants along with, it was alleged that accused applicants along with others trust the husband of the informant and because of the grievous injuries suffered, he was taken to the hospital, Diffu Medical College and Hospital, but he died during his medical treatment. Full stop. The police, after receipt of the FIR, police registered Dokmoka Police Station case number 19/2025 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that this is a typical case of black magic and typical case of black magic wherein the accused applicants have got involved, have alleged to have been involved. Full stop. He submits that
No weapons were used.
Huh?
No weapons were used.
Sorry?
No weapons were used, only hand and pistol.
He submits that there was no intention, in fact, from the accused applicants to kill the deceased person. However, at the very moment, being illiterate persons, they might have been influenced by the statement that the black magic has been done by the accused applicants on the child who was suffering from typhoid. He submits that amongst the accused applicants, accused number 13 and 14 are juveniles being below 18 years of age. He further submits that who were not present, who were not named, 2, 4, 5, 6.
2, 4, 5, 6 are not named.
He further submits that that in the FIR, the accused applicant number 2, 4, 5, and 6 are not named. Full stop. Therefore, he submits that the accused applicants being illiterate persons and being influenced by superstitious beliefs should be granted anticipatory bail at this stage, and the accused applicant shall cooperate with the investigation. Per contra, the learned APP submits that the deceased was badly traced by the accused applicants, and the investigation is still on. Therefore, at this stage, that anticipatory bail should not be granted to the accused applicants. However, he has fairly submitted that as far as 13 and 14 are concerned, being juvenile, the bail to them may be considered by this court as made him fit. Only the juveniles I'm saying, or only about the juveniles.
Yes.
13, 14. He further submits that the informant has specifically named accused applicant number 1, 7, 8, 9,
No,
10.
Malat petition, Malat may mention petitioner number, Malat, I'm saying that accused is so a little bit different, Malat.
No, accused applicant.
Yes, okay.
Accused
Sorry,
applicant.
Malat.
No, usually this code uses the term
No, no,
accused
no,
applicant.
Malat,
Because like this is not a petition kind of, I mean,
no, Malat.
no problem.
The accused names are and.
No, no, accused applicant.
Pull up.
These applicants have been named by the deceased wife, deceased wife. Therefore, he submits that the prayer of the accused applicant shall not be granted. Full stop. After hearing the submission made by the learned counsel appearing for the respective parties and on perusal of the case diary, the instant case, on perusal of the case diary. Is there anything in the case diary? Nothing, I mean, as such now, other than these allegations. This court is of the considered opinion that prayer for bail in respect of accused applicant number 2, 4, 5, 6, 13 and 14 should be allowed at this stage.
3 and 11 also not named. Accused applicant 3 and 11 also not named.
2, 3, 2, 3, 4, 5, 6,
11.
11, 13 and 14 should be granted the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of the arrest of the aforesaid accused applicants, they shall be released on bail on submission of on furnishing of bail bond of ₹20,000 each with surety of like nature, subject to the satisfaction of the arresting authority in connection with
Dokmoka 19 of
in connection Dokmoka police station case number 19/2025, subject to the following conditions. The accused applicant shall appear before the investigating officer within a period of 10 days from passing of this order. The accused applicant shall not try to put the other three conditions. In terms of the aforesaid directions, in this instant, AB application is disposed of as partly allowed.
Obligement. Highly obliged.
May it please your lordship. Lordship, the accused petitioner is in interim bail, my lord. Earlier, lordship, this honorable court, after perusing the CD, enlarged him in interim bail and directed him to appear before the IO for recording the statement, my lord. And accordingly, he has recorded his statement before the IO. FIR, your lordship will find at page 7, my lord. Page 7. May I read, my lord? Very small FIR.
Yes. Mr. Parasar?
My lord, that girl's dead body was found, my lord, after so many days. Subsequently, postmortem also not certain because of that, viscera was sent for FSL. That is not received. But regarding this person, my lord, no directly stated there, my lord, he may, my lord, because some love relation is there along with this person.
But not directly.
Directly, no one has seen, my lord, that he has kidnapped, my lord.
Then you let him go, let him be there. I mean, he will cooperate in the investigation.
Yes.
My lord.
Heard Mr. R. Karim, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned appearing for the state. This is an application under so and so. The allegation is contained in the affair dated 26/9/2025, date on 21/9/2025. The accused applicant allegedly kidnapped the minor daughter of the informant, is at about 13 years. 13 years, full stop. This court, a coordinate bench of this court, by order dated 5/1/2026, allowed the accused applicant to go on interim bail, and it is submitted before this court that as per the aforesaid interim order, the accused applicant has already appeared before the investigating officer. Also, taking into account the aforesaid facts and circumstances, this court is of the considered opinion that the accused applicant the interim bills in protection, interim bills so granted by the accused, interim bills so granted to the accused applicant should be made absolute. Accordingly, the same is made absolute in terms of the conditions, conditions mentioned in the order dated 5/1/2026. In view of the aforesaid, the instant AV application is disposed of.
Oblige your lordship.
May I please, your lordship? Yes, I have, on the last date, interim was granted and I have recorded his statement, lordship.
Let him go, Mr. Heard Mr. P. Sharma.
But one thing is that vehicle not yet recovered, main he is running a agency, he
I'm
is to
disputing
give
it. I'm
vehicle and
disputing
rent, but vehicle was taken, information vehicle was taken, given to other persons. Subsequently, without verifying his documents and all this. Now the main culprit is Kishore Das is also absconding and vehicle not yet recovered. His duty he has given, but he has not verified.
I mean, let him cooperate with the investigation. He cooperate with the investigation, Mr.
Yes, lordship.
You cooperate, you give the details,
Lordship, I will,
but now why the vehicle is not recovered?
Lordship, the problem is that here in the petition, Lordship, I have not taken. They are saying that in the FIR that I have received the vehicle, but I have not received. I'm running a rental agency. It's true, Lordship. But for running a rental agency, whenever we take a vehicle,
But you take a vehicle with proper documentation,
no,
proper
we
verification.
have not taken. There is no iota in the FIR also. They said the Bharveli I have taken, but I have not taken it. That is the dispute in the petition. In the,
Okay, well, okay, let him be there. Heard Mr. P. Sharma, the Learned Counsel, for appearing for the accused applicant. How many are there? One.
One, he has appeared, statement recorded.
Okay, applicant also heard Mr. K.K. Parasar and AP for the state. This is an application under so and so. The gist of the allegations, as narrated in the FIR, is that the accused petitioner, being a owner of a rental agency, car rental agency.
Yes.
Car rental agency, and the informant had rented out his he has rented out his Maruti vehicle to the said agency agency owned by the accused applicant through one Ricky Nath. Also, when the vehicle was not returned as per by the stipulated date, there were some inquiries and it was alleged that the accused applicant unauthorizedly gave the vehicle to another person without verifying the credentials of that person. Full stop. A coordinate bench of this court, by order dated 27/1/2026, has granted an interim bail to the accused applicant, and in terms of the aforesaid order, the accused applicant has appeared before the IA and or his statements recorded. Full stop. In view of the aforesaid, this court is of the considered opinion in view of the aforesaid, as well as taking into account the submissions made by the counsel appearing for the respective parties, this court is of the considered opinion that the interim order so passed earlier on 27/1/2026 should be made absolute. Accordingly, the same is accordingly the same is made absolute in the same terms and conditions as mentioned in the order dated 27/1/2026. In view of the aforesaid, the instant AB application is disposed of as allowed.
Greatly obliged, Lordship.
34 model petitioner is in interim, but we have not received the CD.
See, none appeared for the accused applicant. You appearing? Heard Mr. Your name?
Mohammed Khan.
Heard Mr. M. Khan, the Learned Counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar and AP for the state. The CD in the instant case is yet to be received. Interim order so passed earlier shall continue till the next date of listing. Let the matter be listed on
9th of March, madam.
9th of March.
35, madam, charge sheet submitted.
Charge sheet submitted, you go and appear.
Lordship, matter may be adjourned for the day,
No, no, that's it submitted. Why should be adjourned? He's in interim protection. Let him
Yes.
appear. We'll make it absolute and let him appear.
Petitioner number 2 is interim.
Hmm?
Two petitioners.
There are two petitioners. They are on interim.
Who is on interim?
You have appeared before the IO.
Lordship, that information I don't
Hmm?
right now.
Is there anything, Mr. Parasut?
But, interim to petition number 2,
Hmm.
not to 1,
Not to one?
Not to 1. That is submitted on 25/1, my lord.
So we will give him them both, interim protection and let him appear. He appear. Heard, Mr.
Miss B.
MS?
Devi, Lordship.
Huh?
Miss B. Devi on behalf of Mr. S.P. Chaudhary.
Mr. Ms. B. Devi on behalf of Mr. S.P. Chaudhary, Land Council appearing for the accused applicants. Also heard Mr. K.K. Paraswar, Land APP for the state. Raised an application under so and so. The allegations made in the FIR are to the extent that two persons who were related as two persons who were father and son had abetted the suicide of the husband of the informant. The FIR also refers to a suicide note, which was a part of the FIR also refers to a suicide note, full stop. A coordinate bench, the London Council appearing for the accused applicant submits that in terms of the interim order dated 21/1/2026, the accused applicant number 2, that is Manas Chetia, has already appeared before the IO and got his before the IO, full stop. She submits that both the accused applicants shall cooperate with the. She submits that since charge sheet has been filed in the instant case, this court should allow them to remain in allow them to go on bail so that they can appear before the trial court, full stop. The London APP submits that the charge sheet in the instant case has already been filed by it.
CS number 06/2026 dated 25/1/26.
26. Full stop. Taking into account the proceed facts, this court is of the considered opinion that interim order so passed in favor of accused applicant number 2 should be made absolute in terms in the same conditions as should be made absolute and as far as accused applicant number 1 is concerned, he should be also granted the privilege of pre-arrest bail at this stage till the next date of till the date of appearance till the date of appearance before the trial court, full stop. Accordingly, it is directed that the accused applicant number 1 shall be released and then accordingly it is directed that in the event of the arrest of the accused applicant number 1, he shall be released on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the. Which court is this?
Tinsukia, Sodia.
Odia will be
Tinsukia, my lord. Tinsukia district, my lord, yes.
Tinsukia
but.
or Hodia has the court.
Odia. SDM civil Sapakwa. No.
SDM.
No. Sorry. Sodia, please. Sodia আছে নেকি জানে? Judicial magistrate.
It should be Tinsukia somewhere, but which court?
Judicial Magistrate M. Sodia Sapakwa.
Judicial Magistrate?
M.
Sodia?
Sodia Sapakwa.
Sapakwa. Sapakwa. Full stop. That full stop. Full stop subject to the full stop subject to the following conditions. That the accused that both the accused applicants shall appear before the trial court. That is that you write, huh? That is Sodia Sapakwa something given. SDGM Sodia Sapakwa. Sapakwa on appear before the aforesaid court on the next date of their appearance. Next date of their appearance will do. Next date of their appearance, that the accused applicants shall cooperate to the trial and appear before the trial court as and when required. And then the accused applicant shall not try to temper and hamper. In view next para, in view of the aforesaid direction, the instant TV application is disposed of. Is allowed.
Be obliged.
36.
Please alone.
FR is at page 17, my lord. For Tipkai River, they are smuggling my lord, cows, my lord, in motorboat. Uh, 18 cow and 4 numbers of buffalo. Overseas. Now in page 18, my lord, see, my lord, accused number 3 is Yusuf Ali, son of late Sheikh Saab. Now petitioner is at page 2, he is also Yusuf Ali, care of Danez Ali. So whether he is the same person in the charge sheet also, father's name is Sheikh Saab that is given. If he is not the same person, where is the apprehension, my lord? AB.
Care of Danez Ali you are writing.
Danez Ali.
Where's signed the affidavit? Affidavit. Affidavit, what has been written? Danez Ali.
Well, if he is not the person, my lord, where is the apprehension, my lord?
The police are coming to my house, my lord. Lordship, may I make my submission? It will be very short submission, my lordship.
No, you first clarify the fact.
Yes, my lord.
But, whether you are the same person or not.
Yes, my lord.
Huh? You are the same person.
I'm not the person who are in the accused in the FIR, my lordship. I'm not the person who accused in the FIR, my lordship, written in the accounts, my lordship.
Then where is the apprehension? He is the
police are coming over my house, my lordship.
You are not the person. You show your identity card, you show your details. You give your details.
Page 33, Yusuf.
You go to the court, lower court, and say that I am not the person. Police is coming to my place.
What is the apprehension?
What is your apprehension then?
Already one of my application have been rejected by the learned trial court, my lordship.
You have stated that you are another person. Have you stated that?
It's not appeared in the another.
No. From the record, whether you have stated that.
Lordship, may.
Where is that order?
My lordship, the accused co-accused order is.
The co-accused is different. This court is asking about this present petitioner. Present petitioner is the same person or not?
Lordship, the name mentioned in the FIR It's not me, my lordship.
Yes, if you are not there, I am also saying that you are not there. So where is the apprehension, my lord?
The police is there coming. As
Police
per my
is coming.
specific instruction, my lordship, police is coming to the petitioner home to arresting him. That is why my lordship, the petitioner before this lord. So
No, 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 you said that you filed an application before the trial court,
yes, my lord.
before the lower court,
Yes.
and lower court has rejected it.
Rejected,
I mean, whether that fact was brought to the notice of the lower court,
Lordship, I am not unaware of it, my lordship.
then,
Lordship, can it be?
no, no, otherwise also
Can
there is,
my lordship,
there is
I
nothing,
would like to
nothing.
clarify, my lordship.
শাসিত তো তার নাম Yes, already Sasiret page 28. His name is not there, page not 28. Page 33. Yusuf, son of late Sheikh Saab.
Page
33.
33.
Name Yusuf. Father name is Sheikh Saab. That name in the affair itself. But his name is different, his father's name is different. Petitioner also saying that he is not the person.
Yes,
But if he is not the person, his name is not in the affair, his name not in the Sasid, then where is the apprehension, Mala? Police may Mala searching him for other case, Mala, not in this case.
So may I pray for to take this matter in Monday? I would like to clarify from my client that
Okay, we'll fix it now.
no, the advocate engaged in the trial court, either that fact was brought in the trial court, my lordship. I just sit for 2-3 days in the Monday. I'll clarify the matter, my lord.
Heard Mr. So-and-so, learned counsel appearing for the accused applicant, also heard Mr. K.K. Prasad, and later requested on the prayer of the counsel, learned counsel appearing for the accused applicant, with the matter fixed on 23rd.
Deeply obliged, my lord.
23rd.
Item 12.
Time being. Yes, yes.
If that objection was filed, then that is probably in the record. And today, Lordship, as on today, 57 days.
What is the quantity?
1 kg, 463 grams. Lordship, and commercial quantity is 20 kg. And small quantity is 1 kg, Lordship. From just above small quantity, this contraband is found.
How many days?
57 days as on today, Lordship.
Yes, it is correct, Lordship. Contraband seized was the intermediate quantity.
Intermediate quantity 57 days.
60 days.
57 days already gone.
Let
Let
him, Lordship, up to your Lordship.
let him go, let him. Heard Mr. A.K. Azad, A. Ahmed, learned counsel appearing for the accused applicant, also heard Mr. S.C. Kayal, the learned standing counsel.
Custom law.
Learned standing counsel, Customs Department. Full stop, please, an application under so and so. An FIR was lodged. Is it a complaint, no? Complaint.
Complaint is yet to be filed.
Huh?
Complaint is yet to be filed.
Complaint has to be filed. And this is what, the initial?
Initial Lordship remand order, remand application.
But why, what is this complaint you have written, Mr. Ahmed?
This is, as per my knowledge, Lordship, this is called initial complaint, and when they, Lordship, file their charge sheet, that is called, Lordship, a final call.
That is the, I mean, complaint actually. Okay, we can, term is the initial complaint or not?
Lordship, this is nothing but a remand application. We after arresting.
No, what is it termed actually?
Lordship, remand application.
Remand application. Okay, as per the remand application dated 25/12/2025, it was alleged that on screening of the luggage of The allegation is directly not against you, Howard.
Allegation is against me, Lordship.
Lordship,
Matlab
In
He-
my luggage, that quantity was, from my luggage, that quantity was recovered.
okay, you show me where you have written in paragraph 3 that from your luggage it has been recovered.
At Lordship, paragraph 3, 1, 2, 3, 4, 5, 6, 6 line.
Hmm.
During screening of luggage of incoming international passengers, a suspicious item was detected in the baggage scanner at the airport.
Okay, okay, got it. While screening the hand baggages, it was alleged that from the hand baggage of the accused applicant, what was the quantity?
Quantity, Lordship, 1463. Next page.
1463 grams of dried greenish colored material suspected to be cannabis was recovered from the accused applicant. Full stop. Accused applicant. Full stop. Full stop. Then you write the learned counsel, appearance of the accused applicant submits that the accused that on the basis of the aforesaid forwarding application, the accused applicant was arrested and he has been inside the jail for last 57 days. He submits that the quantity recovered is for personal consumption and the same is of intermediate quantity, and that therefore taking into account his custody, taking into account his length of custody till that, the accused applicant should be granted bail at this stage. Full stop. The learned standing counsel, customs department, however, opposed to such bail. Full stop. Next paragraph, after hearing the after taking into consideration the affidavit filed by affidavit in objection filed by the customs department, as well as after hearing the submissions made by the counsel appearing for the respective parties, this court, and also taking into account the length of detention of the accused applicant, this court is of the considered opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith from the judicial custody on furnishing of a bail bond of rupees 50,000 with two sureties of like nature, subject to the satisfaction of the which court?
Special Judge NDPS Kamrup
Metro. Subject to the following conditions, that the accused applicant shall appear before the IO as and when required, that the accused applicant shall not try to put it clause, shall not try to influence any witness, then that will do. In terms of the aforesaid direction, this instant bail application is disposed of as allowed.
Macho. Obliged.
M6.
Received anything?
Some 5 months.
We'll fix it on Monday. You also get some information if you have.
My son is appearing in the SSLC examination also. He's appearing also.
He's
Police is also.
his son is appearing. He's not appearing. I mean, now you also do not have any information whether any complaint is filed or not.
That is not registered. That is not registered. But FRI has been filed also by the respondent number 2.
What is to be done? I mean, see, he is apprehending. No, FIR, what is the allegation against you?
Lordship, what happened, Lordship, in this case? There was an agreement between the petitioner and the respondent.
Now, I understand some land dispute, I mean, the land this thing. Now, what is the, I mean, what is the, I mean, you said that some FIR has been filed.
FIR has been filed.
File what?
For settlement of the dispute, Lordship, because in
The FIR cannot be filed for settlement of
yes,
dispute.
that is why, Lordship, they have, along with the FIR, Lordship, they have brought one agreement, Lordship, wherein they have said that I have taken rupees 2 lakh for amicable settlement of the title suit. I will withdraw the title suit. That is the
FIR cannot be filed for amicable settlement.
FIR along with the plot document, Lord, wherein they have stated that I have accepted rupees 2 lakh for amicable settlement of the land dispute, Lordship, and I withdraw the.
Mr. Borua, this is a AB application. I mean, how can we keep it just like that? What is to be done? Tell me.
He'll mandate Lordship may protect him, my lord. He'll mandate. He will receive any information.
See, it's become difficult and later on, I mean, it is found out that there was no complaint filed, nothing happened. High Court has granted bail without having any basis.
Lordship, I have given a specific statement, Lordship. The police has come on my house, Lordship, on 4/2, Lordship. 4/2/2026, and he has been repeatedly calling me. I have also given the name of the OC of the Howli police station, Satyajit Bhattakur. He has been repeatedly calling.
For polling on amicable settlement, also police might sometime, my lord, call the accused person, my lord.
And also, during the last pendency of the title suit, they could not file a
Why don't you try to contact this?
So we are not been able to obtain the instruction, my lord, only matter whether the FIR has been issued. Or let it come tomorrow, my lord, then tomorrow.
The OC you can contact, na? I mean, find out.
Instruction received from our office that no case is registered till now. Yes, but we want retain because some days something new has come, so retain we have not yet received.
They will keep it for tomorrow. You just wait for some time. I mean, it becomes difficult without any, I mean, let the matter be listed tomorrow. Tomorrow you find out something. I mean, something concrete.
Item 20, 21 and 44.
Let my learned friend start, my lord. I'll go to the case and I'll make my submission tomorrow, my lord.
You could not have been able to go
So,
through.
I have also kept my learned friend waiting from morning itself, my lord. So let his argument go.
There's nothing, my lord.
You want to argue today or like you want to keep it for tomorrow? I mean, otherwise also he is not going to do it.
No, I can wait, my lord, no problem. My lord. But otherwise also there is nothing. My case is very simple. 4 person has been apprehended. While
Mr. Bora, all your cases are simple. Anyways, I mean, we'll hear it.
I have annexed all the document where from all the money I got it, madam. It's not that the 70.
How much money?
70 lakhs cash and the checks. So
And
nobody
how many students were there? I mean,
students, no. So there are basic initial allegations that the one person from the USTM, he was accompanying with the owner of the car and the money. So they are going towards Meghalaya. Basically, initial allegation was that they are carrying the money to deposit in the USTM for the purpose of admission. But when the person of the USTM was apprehended in the car, they have changed the entire allegation. Now they have made it a allegation that it's a money belongs to some illegal activities. Now we have been apprehended on the previous day. On that day, we have registered an agreement with somebody. Land. I have sold the land to one ACS officer on previous night. There is a registered agreement there also. I have received that amount, that 58, along with all the checks. That's also mentioned. So
we'll hear it tomorrow, then, Mr.
that's
Pare.
the case only, my lord.
We'll hear it tomorrow. He's having some difficulties today. I mean, let them also give some fair opportunity.
Yes.
Tomorrow we'll fix it. Heard Mr. A.M. Bora, the learned counsel, learned senior counsel, is the Prime Minister D. Beddo, learned counsel for the his applicants. Also heard Mr. R.J. Borua. Mr. Borua submits that he needs some time to go through the voluminous case diary in view of the aforesaid submission. Let the matter be fixed tomorrow.
Tomorrow, my lord, can it be, my lord, initially item, my lord, at the motion, after the motion? Possible. After the motion, my lord.
After the motion items. This is for bail, what, hearing?
He agrees, my lord.
Yeah, no problem.
Okay, okay.
Full mention.
Okay, Mr. M.A. Sheikh also appears for item, for the accused applicant, item number 44, you write, huh? 44, you write.
Public.
So all these three together items, 20, 21 and 40, 44, list together, no?
Public.
पहले लिस्ट को दीजिए इधर से अपना हेरी करने हैं कि अपग्रेड है ना वो साइन अप
25.
it possible negative possible yes yes CD hasn't received
Case I received, my lord.
yes
Petitioner was in the interview and they appear, my lord, their statement has been recorded.
what is the allegation
Allegation, my lord, with page number 10, my lord.
suicide
Suicide one.
Mr. Borua
My lord, we have received the case diary, my lord, along with the postmortem report, my lord. As per the postmortem report, my lord, her, my lord, ligature mark is non-continuous, my lord.
ligature mark
Not non-continuous, my lord.
non-continuous
Continuous.
that means maybe a case of
Case of suicide, my lord, but in the, my lord, postmortem report, my lord, final cause of that has not been ascertained because the FSL report has been, my lord, sought, report of the FSL, my lord, was sought for. Now, my lord, FSL report also received, my lord, there are no such poison, my lord, in the FSL report. In the FSL report also received, my lord, no poison found in the FSL.
no poison allegation is what
Allegation is that, my lord, it's a case is registered, my lord, under section
80 of BNS.
80, 35 of BNS, my lord.
Allegation is the same. So after marriage, dowry has been demanded. On 11/4/25, she went to her parents' house, and on 12/4/25, come back to his in-laws' house. And 13/4/25, she committed suicide without any reason, my lord. And after the incident, the husband and father-in-law was arrested. And in this present petition, my lord,
they're inside the jail
No, my lord.
subsequently released, my lord.
they've been garnered in one bail
Lordship. And
and yeah, this present petitioner is who
his sister-in-law and mother-in-law. Sister-in-law married,
so let them go let them go heard Mr.
They have
H.
appeared, my lord, let them cooperate with the investigation.
Yes, I heard Mr. H. Ahmed, the counsel appearing for the accused applicants. Also heard Mr. Ajay Bora, and APU for the state. This is an application under so and so. The gist of the accusation in the accusation as narrated in the FIR dated 13/4/2025 is that is that the accused persons is that the accused person you are named in the FIR, both of you.
Lordship.
The accused applicants were subjected the daughter of the informant to physical and mental torture and due to that she committed suicide. Full stop. Full stop. The learned counsel appearing for the accused applicant submits that the main accused in the incident case, the husband of the deceased as who are given bail.
1 and 2, husband and father-in-law.
The husband and father-in-law of the deceased have already been granted bail. Bail by whom? Bail by which court?
This honorable court in BA number 6.
Okay, they are granted bail by this by a coordinate bench of this court. Full stop. This court or different court?
One by this court and husband by the trial court, my lord.
This court means what? I mean, this court.
Lordship. High court.
Okay, already granted bail by this court. Full stop. No, by a coordinate bench of this court, by a coordinate bench of this court, full stop. Wide an order dated 2/6/2025, the accused applicants were granted interim protection, and in terms of the aforesaid order dated 2/6/2025, the accused applicants have already appeared before the IO and got their statements recorded, correct? Recorded, full stop. He further submits that the accused applicants will cooperate with the investigation and make themselves available before the IO as and when required, full stop. Case diary in the instant case has been produced before this court, and the same is perused, full stop. The learned APP, however, opposes the bail to the accused applicants at this stage, full stop. Taking into consideration the entire facts of the case, as well as the bail orders of this court, and the interim order dated 2/6/2025, this court is of the considered opinion that the interim order so passed on 2/6/2025 should be made absolute. Accordingly, the same is made absolute in the same terms and conditions as stated in the order dated 2/6/2025. In view of the aforesaid, the instant bail application, AB application is disposed of.
29.
I'm sorry, Your Lordship. This 9 is the FR law. The allegation is very serious one, Lordship. The background of the case is something different. The allegation is put by the daughter upon the father, Lordship. That page 9. I'd like to draw attention, Lordship, on page 20, Lordship will kindly see, this is a complaint petition regarding some monetary transaction with the in-laws, Lordship, by this accused person. Page 20, Lordship will kindly see.
At this stage, I mean, all these things are immaterial.
No, Lordship will kindly see the thing, Lordship, that
No, let me see this. What is?
Those are 183 statement.
the victim statement, Lordship, it is not telling with the contents of the FIR, Lordship. Complaint was filed, Lordship, when the notice was issued, summon was issued by the learned trial court below, Lordship. After receiving the summon, the instant FIR has been filed against us, Lordship. All the person has been named in the complaint petition, Lordship. And the
complaint was filed by whom?
By the accused person, Lordship.
When?
That on 11/7/2025. Page 20. is
By the accused person against?
Against his wife and in-laws, Lordship, and the information.
And when his wife was divorced?
Divorce, Lordship, prior to that, Lordship.
Prior to that,
19/6/2025. 19/6/2025, Lordship.
19/6/2025.
Lordship. And these are regarding the dispute regarding the transaction.
And you have filed this complaint on 11/7/2025.
2025. Complaint, Lordship, and the page 22, Lordship will kindly, page 20.
Only at this stage it will be difficult. Serious allegations.
But the statement of the victim of the statement says something else, Lordship.
In a similar nature, I mean, it's a small, small kid. It will be difficult, Mr. Munir, that at this stage.
That I understand, Lordship, because of that, after receiving of the summon, Lordship, only we get.
No, that,
considering the breakdown of the facts,
those,
Lordship,
see, I mean, the divorce happened prior to filing of this CR.
Lordship, that definitely, she left away, Lordship, because of the transaction of the money. it was
Yes,
3
yes,
lakh.
yes, understand, but like but those.
And the daughters were also, Lordship, when she was dropped away from the home, Lordship, the daughters were.
See, I mean, daughter alleging a
they
father,
were taken with
the daughter alleging a father, it's not very natural, you know. I mean,
that
in only extreme circumstances, it is done. I mean, if there was some inducement, then that will be found out in during the trial.
No, that I understand, Lordship. As per the information, Lordship, when the wife went away from the house, Lordship, she took the daughters also, Lordship.
No,
And
she
daughter
didn't.
is
No,
deciding which.
I mean, she didn't take the daughter at that date. I mean, on 9/6, I mean, the divorced her and evicted her. And after the woman left on, then I mean, allegedly brought some other woman. Then when the other woman was not there, and 13/7 she was there.
That is
That's why it happened.
Lordship, it says something, Lordship. Yes, says that she, the extreme point, Lordship, where it is mentioned in the FIR, Lordship. And his statement, Lordship, it says something else, Lordship.
Statement also more or less same. And who is this? The sister, one of her sister is also, I mean, stated the same thing. There are materials, Mr. Munir, it will be difficult. Heard Mr. S. Munir, the learned counsel, appearing for the accused applicant. Also,
Appear then, Lordship, that much can be done.
No, no, no.
Appear will appear.
at this stage, no, serious allegations.
It is
Mr.
charge-sheeted, Lordship.
This court is otherwise liberal, but
Lordship, I understand.
but when the case is not
Lordship.
something, I mean, where interference is not required, then the case court will not. Heard Mr. S. Munir, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwa, the learned APP for R.J. Burwa, learned APP for the state, as well as Mr. D.K. Bhattacharya, the amicus curiae, appearing for respondent number 2, informant, full stop. And if this is a right, this is an application under so and so. An FIR was lodged on 13/8/2025 by one. She's the mother. No, she's the victim. She's the victim. Yes.
Daughter.
FIR lodged by the victim, alleging that after the divorce of her mother, on 19/6/2025, the father, that 5 comma, her father brought in another woman to their house, full stop. However, on 13/7/2025, when the aforesaid woman was not present at about 12 a.m. at night, her father tried to seduce her and possibly rape her. Say, on raising hue and cry, her other sisters came in and rescued her. Full stop. The police, on the basis of the FIR, police registered Lahorigarh PS case number 184/2025 25.
You have lost before the SP, Lordship, and later on 1/9. It was filed before the SP of Morigaon.
Okay.
And they're forwarded.
You can write the that file before the SP, SP Morigaon.
They were forwarded to Lahorigarh.
Forwarded to filed before SP Morigaon, and the same was forwarded to Lahorigarh police station, and accordingly Lahorigarh police station case was registered. Okay? Registered. Mr. S. Munir, the learned counsel appearing for the accused applicant, submits that in fact the FIR has been falsely lodged by the informant, by the victim girl, as there was some dispute going on between her mother, who had already been divorced by her father, regarding some
Monetary transaction.
regarding some monetary transactions, full stop, full stop. In fact, the incident did not occur at all. And the and the affair was lost on the instigation of the mother of the victim girl, that is the informant, full stop. The learned, therefore he submits that at this stage, he should be granted the granted pre-arrest bail, so that he can cooperate with the investigation, full stop. The learned APP on the other hand submits that there are serious allegations against the accused applicant, accused applicant C being the daughter of the accused, full stop. Therefore, he submits that at this stage, the prayer of the accused applicant should not be allowed. Mr. D.K. Bhattacharya, learned amicus curiae, has also supported the submission made by the learned APP, full stop, taking into account the materials brought before this court by the trial court record, as well as taking into account the submissions made by the counsel appearing for the respective parties. This court is of the considered view that at this point of time, the accused applicant does not merit any relief from this court, and accordingly, the instant AB application is dismissed as rejected.
Much obliged, your lordship. Much of.
Not a case at this stage.
Much.
48.
কি হয় এইটো কি হয় আছে নেকি বেলেঞ্চ আৰু কেইটা আছে 48 last time also nobody appeared. Anyways, none appeared for the petition, for the petitioner when the matter was called for the interest of justice. Let the matter be fixed on 26th. No, not 26th, maybe on 25th. হেৰি বৈশ এই কোনটো মেটাৰ পাতিছে মিষ্টাৰ আগ্ৰৱাল ইজ এটা কোনকেইটা আছে মেটাৰ এডমিশ্যন নালাগে এতিয়া এই হিয়াৰিংটো মাতি দিয়া ৰখি আছে কাৰণে এডমিশ্যন কোন আছে নেকি কোনোবা এটাই আছে নেকি এডমিশ্যন বুজিছো এটাই আছে মাতি দিয়াচোন বাৰু কোনো নাই যেন
46.
Kindly adjourn the matter for a day.
On the prayer of the learned counsel appearing for the petitioner, let the matter be adjourned and be listed on in the first week of March.
Section 50 order.
Mediation গৈছিলে মানে
Nobody is appeared, nobody is there, the other side.
Mediation but failure.
None appeared when the matter was called for the petitioner. Let the matter be listed first week of March. However, Mr.
M. Sharma.
M. Sharma, the learned counsel, appeared for respondent number.
Respondent number 3. Your
Respondent number 3 and P. Maheshwari for respondent number 4. Okay. Let the matter be listed in the first week of March.
38.
Victoria.
Yes, Mr. Rao.
May I just raise the facts first?
Yes, yes.
So the short question here,
Mm.
that the learned session judge, while passing the judgment,
Mhm.
setting aside the accuser,
Mm.
relied on a judgment which was already not set aside by the learned session judge earlier.
Okay, session judge, okay.
I'll just give the facts.
Mm.
My lord, here the case is that, my lord, on 16/4/2007, allegation is
Mm.
the petitioner assaulted petitioners, all the petitioners, they were police officers and home guards.
They are police officers.
Police officers, all are police officers, and some home guards are there, my lord.
Mm.
My lord, may I take to your lordship the Aadhaar, Annexure 1.
Annexure 1.
Annexure 1 at page 26, my lord.
Page 26, okay. Yes.
With due respect and humble submission, my lordship got it.
Yes, yes.
I, the above stated informant, would like to inform you that on 16/4,
Mm.
it is Monday night, SI Sibab Chaudhary, along with few constables under your police station, had severely beaten my youngest son, Vicky Khan, and caused grievous physical injury at Marketer Central Field, Bihutoli. Therefore, I request you to look into the matter with the due consideration and take necessary action. Now, Josna Begum, the mother, lodged the FIR. She is the PW3, my lord. I'm sorry, PW1. It was lodged on, my lord, 25/4/2027.
What was lost? FIR?
FIR was lodged. 16
25?
incident took place, my lord.
Okay, 25/4, but on the top it is 21/4/2007.
21. But it should be 25 my lord. The original to us. I have given the original also, my lord, the certified copy. 25/4/2007, my lord.
Hmm.
25/4/2007. Your lordship will kindly.
But on the top it is 21 in the
Yes,
original also.
true, your lordship is rightly pointed out, my lord. But in the certified copy,
Hmm.
SD, my lord, that's you are right, my lord, my lord is rightly pointing out.
Mhm.
But it's seen on 21/4/2007.
Yeah, it was filed on 21.
Page 27, your lordship will find. Page 27 is the certified.
Yes, it's there.
I think 21. Hmm? I don't know. My lord, that will not make any difference.
Make any
in this
difference,
case.
yes,
Just because
That
your
will not
lordship
make
has
much
rightly pointed
difference.
out that it was seen on 21, but it was filed on 24, it cannot be, my lord.
No, it was received and
Yes,
registered on 23. That. Anyways.
That will not, my lord, I am not on.
Anyways.
So, a case was registered under section, my lord, 325/34 against all the petitioners.
Mm.
Then, my lord, on 1/6/2007,
Mm.
on 1/6/2007,
Mm.
a final report was given, my lord.
Mm. Which is at?
No, that report.
That you have annexed or it's?
No, not annexed. That
Okay.
is not, my lord. Factually, I have
Okay.
stated in paragraph, my lord.
Okay, on 25?
1/6, my lord, 2007.
1/6/2007. Okay.
It is a final report was submitted, my lord.
Mm.
Then, my lord, on 7/8/2007,
Mm.
the learned, my lord, SDGM Margherita,
Mm.
my lord, by its order, directed the officer in charge Margherita PS for reinvestigation and submit report.
So he was not satisfied with the effort.
No, sir. My lord, reinvestigation could not have been, my lord, but it should have been challenged at that point of time, my lord. I'm not arguing all that because the Supreme Court says that he has no power to give the reinvestigation all that. But anyway, my lord, not from that. Now, thereafter, on 1/9/2009, the trial court altered the, it came from, my lord, accordingly, Sub-Inspector S. Sham submitted charge sheet against the petitioners under section 166/325 IPC.
So it was filed on 1/9.
1/9. Yes, it was an idea. No, 1/9, not. 1/9, my lord, the charge was altered.
The charge sheet was filed prior to that then.
Charge sheet was filed prior to that, my lord.
Hmm.
Then, my lord, on 34,
No, charge was altered for what?
charge was the trial court.
Initially, charge sheet was filed on different,
Let me check and my lord tell my lord. I'm sorry, my lord. The Learned Trial Court by order after recording statement of informant directed the marketer to reinvestigate that on receiving the summons appeared before the trial court. Thereafter, particulars during trial on order at the stage of evidence of the case. My lord, the other facts are not there. So, my lord, I'm just pointing out that in the meantime, the trial started after filing the charge sheet. Oh, it was not the charge sheet, my lord. After reinvestigation, the matter was, my lord, charge sheet was filed. Thereafter, trial started. During the course of trial on 1/9/2009, my lord, charge was altered, and it was framed under section 166, 325, 34 IPC.
Okay.
Then, my lord, the prosecution examined 10 witnesses.
Hmm.
And my lord, ultimate statement under section 313 of the accused persons were recorded. And my lord, on 34/2011, my lord, by judgment, my lord, annexure 2,
Hmm.
annexure 2, my lord, they were convicted, my lord. If your lordship, my lord, I'm not reading at this stage the entire page.
Yeah, no, not required. How many were convicted?
My lord,
All of them.
All, my lord.
So accused 1, 2, 3, 4, 5, 6 persons. 6 persons were convicted.
My lord, your lordship, page 37, my lord.
Yes, yes. Absolutely.
Accused Shiva Prasad Chaudhary, Tireshwar Gogoi, Tukeswar Chetia, Rajiv Chetia, Nilakanta Bora, and Jeevan Kumar Taya not found guilty under section 325-34 IC. And they were acquitted of that charge. Accused Shiva Prasad Chaudhary, Tireshwar Gogoi, Tukeswar Chetia, Rajiv Chetia, Nilakanta Bora,
Found
Jeevan
guilty
Kumar
under
Taya,
66.
guilty under section 166, 34, and their bail stands cancelled, and they are sentenced to pay a fine of rupees 1,000 each. So and so and so and so and so, my lord. Then,
Yes.
my lord, we challenge this order.
Yes.
Then, my lord, your lordship will find the appellate court judgment. At page 38, my lord.
38, yes.
My lord, your lordship will find the ultimate page 43. A discrete scrutiny of materials, para 9, demonstrates that in an instant case, the prosecution all along claims the victim was severely assaulted by the accused persons causing grievous injury. On the other hand, the defense had pleaded that at the relevant time he was fully intoxicated and he sustained injury as a result of jumping out of the auto rickshaw. Under the above circumstances, the driver of the auto, Mintu Pradhan, is found to be most material witness to arrive at a just decision of the dispute between the parties. The name of the Mintu Pradhan appears in the charge sheet as witness, but the prosecution failed to examine him without assigning any reason. The Learned Trial Court, under the facts and circumstances of the case, could have exercised jurisdiction conferred by section 311 to appreciate the materials available on record judiciously in a proper way. Without resorting to the legal provisions of the Learned SDGM, consider the statement of Mintu Pradhan under section 161 CRPC. Section 311 provides that any court made any stage of inquiry, trial, or other proceeding under the court summon any person as a witness or examine. I'm skipping. Then para 10. Considering the entire discussions coupled with the legal provision, I am of the opinion that this is a fit case to remand for fresh adjudication. In the light of observation made in the discussion, the Learned Trial Court is at liberty to examine further materials witnesses other than Mintu Pradhan. Consequently, the appeal is allowed as the case is remanded for fresh trial in the light of observation made in the discussion in accordance with law. Now, my lord, what I'm trying to make my lord, that the earlier judgment of my lord 34/2011, that is annexure 2 judgment, my lord, that was set aside, my lord. Though the word set aside is not there, it has been set aside and matter was remanded back. Thereafter, my lord.
But what is this line? The Learned Trial Court is at liberty to examine further material witnesses. Other than Mintu Pradhan, Mintu Pradhan has to be examined, but other than Mintu Pradhan, that can be examined. That is the my lord main issue. Now, my lord, the other than Mintu Pradhan will mean that Mintu Pradhan should not be examined and other people should that, be examined. my lord, seems to be that, my lord, but my lord, probably, my lord, from the earlier discussion, it transpires that Mintu Pradhan is one of the. That's what, and that's why I my mean, lord, yeah, rightly pointed out. that's why I found a little bit of contradiction in the maybe the language. Language. Now, my lord, thereafter, Mintu Pradhan was examined as PW11, my lord. Okay. On 21/3/2000 and exhibited two more documents as exhibit 8 and 9. Therefore, respondent number 2 filed an application under section 300 CRPC with a prayer to examine more witnesses. Then the learned trial court, my lord, this was the order, my lord. Then on the learned trial court by order dated 18/5/2012.
Where is that order?
My lord, the order is not annexed, my lord, here. My lord, I am just making the submission.
Okay.
Because I have given the fact. On 18/5, the learned trial court by order rejected the said prayer. Against the said aforesaid order of respondent number 2 preferred a revision before this honorable court, my lord, which was registered and numbered as criminal revision petition number 292 of 2012. Then, my lord, this honorable court by order dated 7/2/2013, my lord, dismissed that said criminal petition. So, my lord, the question of further examination of witness as paid by respondent number 2 was, my lord,
Not considered.
now,
Reject.
the next, after examining the Mintu Pradhan and all that, my lord, the judgment was passed on 27/8/2013.
27/8.
Yes, my lord.
Yes.
The lordship will find at page 45.
Yes.
My lord, I am coming to the part, page 53, if your lordship kindly.
53.
53. In the result, I find and hold that the prosecution has failed to bring home the guilty of the accused persons labeled under section 325, 166, 34 IPC. Beyond all reasonable doubt, accordingly, I accuse the accused persons from the above charges of law and set them at liberty. Forthwith, the bail bonds stand cancelled and the bailer is discharged from the liability. So, my lord, we were acquitted. Against that, my lord, the respondent number 2, my lord, they preferred an appeal before the learned session judge under the proviso of section 372, my lord.
Yes.
Now, my lord, in the that ultimately, finally, the matter was heard, and by judgment and order dated 19/2/2015, my lord, the appellate court reversed the judgment of acquittal.
Yes.
So, my lord, may I just draw your lordship's attention? Now that your lordship will find at page 54, the judgment at answer 5.
Yes.
Lord, if your lordship kindly come to page 61. My lord, prior to that, my lord, if need be, I'll place, my lord.
Yes.
I'm trying to, my lord, that sort.
Yes.
11 at page 61. I have also produced the evidence of other witnesses examined by the prosecution and also gone through the judgment and order dated 27/8/2013 passed by the Renner SDGM, acquitting the accused persons from the charges leveled against him. I have also gone through the judgment dated 30/4/2011. My lord, this judgment was already set aside now. Passed by the learned SDGM Margeta, convicting the accused persons under section so and so, acquitting the accused person under section 325/34 IPC. Now, my lord, I'll directly come to next page. Para 18, page 64. my lord, Mary, considering the evidence of the witnesses on record and after perusal of the judgment dated so and so passed by the learned SDG Margareta in GR case convicting the accused person, I am of the considered view that there was no irregularity or illegality or infirmity by passing the said judgment. Accordingly, I am of the view that judgment order passed by the Margareta dated 27 is required to be set aside, and accordingly same is set. Hence, I have upheld the judgment of the learned SCGM Margareta dated 34/2011, with slightly modification that accused persons, namely so and so, so and so and so and so and so and so, guilty under so and so, and they are sentenced to pay a fine of rupees 10,000. I have also found the above named accused persons guilty under so and so, and accordingly they are sentenced to such. Because the judgment which was already set aside. That cannot, that can't be relied on, and the finding given by that court cannot be taken into consideration. My lord, if need be, my lord, I just again place, my lord, this 34, because the 34 judgment was set aside, my lord. Yes, it was set aside, then against, I mean, it was sent back again. The case was remanded. It was set aside, my lord, sending back and directing that you examine fresh witnesses and all that. But the judgment will not remain there, my lord. Therefore, a fresh judgment has been passed by the learned trial court. Yes. Learned trial court, my lord, on 27/8/2013, passed a fresh judgment acquitting all the accused persons. Well, that can't come into consideration at all, my lord. So you are saying that, like, I mean, I have upheld this sentence, hence I upheld Okay. the judgment of the then SDCM so and so 34/1 Yes. with slightly modification Ah. that the accused person so and so so and so. So you are saying that that judgment is already been set aside. The judgment is not in my lord yet. Hmm? The judgment is not there in record, because if you, my lord, the word set Because aside is- because that judgment is already gone and a fresh judgment was the judgment passed. has come on 27, my lord, and that judgment is challenged before this honorable court. My lord, had it been a case that, my lord, on merit applied mine and thereafter the set aside the acquittal, my lord, I can argue on merit even today also, my lord. In this case, if your lordship wants, I can argue on merit also. Even merit, my lord, that cannot be sustained. But my question is that, my lord, since that cannot be done, and that has been done illegally, but matter may be sent. Okay, let us say 34 exactly what, no, not 34, the other judgment, 27, 27. that page 45. Page 45, the part, which penultimate part is page 53. Because Mintu Pradhan was examined after 34. It was remanded, then Mintu Pradhan was examined to. So it was basically your argument is that that 34 is already set aside, and it was, I mean, it was remanded back to examine this. I mean, Mintu Pradhan, and on the basis of the fresh evidence, a judgment was passed. So that judgment is no longer there. So that judgment cannot be brought in again and relied on and like modified, because that judgment is already not there. If modification can be done only in the on materials, the session judge could have done independently without that judgment also. No, without the judgments also, but he has taken into that consideration. The consideration is okay, but like he said that judgment should be modified. Modified and upheld the judgment. Upheld the judgment. This judgment can't be upheld, my lord. Because it's already gone. This earlier learned session judge has set aside that order. For all intent and purpose, my lord, though word is not settled. So, my lord, my humble prayer that, my lord, without going into the entire merit of the matter may be remanded back, let it be heard, face, and judgment will be passed. They will also get the opportunity. Otherwise, I have a good case on merit also. Because all the evidence, my lord, is against, my lord, what they are trying to say, the respondent number 2.
the mother lodged the FIR, my lord, on 21/4. Incident took place on 16. She stated in her evidence that his son was, he was not in a position to speak anything. He told him about the incident after 2 months. So how can she say that the police officials had beaten him and yeah. Medical report is also against. Medical report says that it was a traffic accident injury.
But Mr. Agarwal, remanding back will again consume time. Then again,
Then it will be heard and made, my
no,
lord.
on the only to say this is one contention, obviously that has to be considered. I mean, before passing this, I mean, if this court thinks that the matter should be heard on merit and judgment should be passed, then obviously that contention will be there. That has to be considered. Because that is a very valid point you have raised that has to be considered. But only thing is that this court is thinking, okay, that is a point you have raised that will be definitely taken into account. But otherwise, only on the basis of that submission of yours, if this court finds that there is a merit in the submission and send it back, then again it will consume some time. That's what
That's what I have just not taken the first on this point only.
Yeah.
Because your lordship can see patently illegal order. It cannot be murder stand. And that is the first ground, my lord.
That also cannot be brushed aside.
But why I am saying, my lord, that they may not have any grievance. They can argue the matter again.
Yes, Mr. Datta, what is your?
It may be fixed, my lord. Your lordship can fix a date there. Both the parties will, my lord, they will have a notice here itself. They will appear there and argue the matter.
My lord, the ground set for the by the petition.
No, Mr. Doctor, see, a very simple, simple and very clear thing. First thing is that one judgment was set aside. It was remanded.
Yes.
Correct.
Yes.
And the matter was heard again, and judgment was passed. So that order, that earlier judgment has gone. That is no longer there. That is set aside. Now, whether the appellate court can bring in the judgment again, consider the judgment, then say that like I upheld that judgment, which is no longer there.
My lord,
in front of the eyes of law.
My lord, the court can refer the case for any lacuna to fill up the lacuna.
No, what lacuna?
313, my lord. Under section 313 CRPC.
You see, Mr. Doctor, you simply answer one thing. Whether it can be done when a judgment has already been set aside by a superior court, then again whether when the judgment is set aside means that's gone. That has become a non-entity. Now, can that be again upheld?
But the case was proceeded in the same GR case, my lord.
It may be in the same GR case. It always it always proceeds in the same case only. It doesn't. There is no separate cases are filed for separate appellate forums.
But the The court, the learned court invoked the jurisdiction of 313, my lord.
Understood.
In any stage,
you
court
want-
can refer the case for further hearing of such, or someone to some witnesses.
But
which
do you
is
want to say that judgment was not set aside?
Not set aside.
Judgment was not set aside.
As per the provisions of.
But the language doesn't say so. It was, if language is not like that the case is set aside and it should be heard from this stage again. It isn't stated like that.
But how the.
It was stated that it was heard, it will be heard afresh. See, the language is considering the entire discussions coupled with the legal provisions. I am the opinion that this is a fit case for remand for fresh adjudication in the light of the observation made in the discussion. So fresh adjudication means what? It's not from the stage. I mean, it is not that against some. No, it is not like that.
But any court.
See, there was no direction stating that we are remanding the matter. You only examine this person and give a judgment. It's not like that.
Even in that case also, my lord.
It has to
The
be set
judgment
aside.
goes.
That's
Lord, had it been a case that no, this was not witnessed, you examine and send the record here.
Correct.
So that the session just can consider.
Usually you have to set aside that and then you may ask for, okay, I mean, whatever is procedural, that is record, you can consider that. And in addition to that, you come examine those people. That can be done, that is being done maybe. But judgment has to be set aside. The stage may remain.
Yes.
I mean, whatever the witnesses, whatever statements are there,
Those are not.
those are untouched.
Not.
Those will be there.
Those will remain
But
there.
in addition to that, some other witnesses will be examined. And on
once
the
fresh-
basis of those additional.
Once fresh witness is examined, you know, the defense will be getting 313 will be recorded.
Examined it.
313 will be recorded first and defense will be given an opportunity.
On the face of that earlier judgment, it cannot be heard again.
And Mintu Pradhan was examined in this case, my lord. I have prepared the paperwork of the witnesses and all that. Those are not annexed with that, my lord.
Section 311 provides that any court.
311 my lord 2, 311 my lord the court's power. In the judgment, when remanding back matter, my lord, the court has taken into consideration 311. That the court's power is there. The court should have, instead of taking into consideration 161 statement, the court should have examined the.
That was
Lord,
recorded. That
161
was,
statement is a police statement, cannot be taken.
that has been recorded here also.
Yes,
On the order.
That is recorded.
On the order also, it has been recorded.
So your Rossip rightly pointed out, they should not have said, my lord, that examine other witnesses besides my lord, yeah. That should have been clear, but anyway, my lord, ultimately PW 11 was examined. Now they filed an application under 311 in the trial court. That was rejected. They came before this honorable court. This honorable court also rejected. My lord, in that matter also, I appeared for the, my lord, the petitioners.
Set aside.
Kuntu. Set aside, Hobdon, set aside. You see kindly 53.
44.
53. Oh, sorry, 44.
44.
44, sir. No, 44.
See, consequently, the appeal is allowed.
Consequently, the appeal is allowed and the case is remanded for fresh trial in the light of the observation made in the
Then
discussion.
what remains?
Remanded back and fresh trial.
My lord, observation is a section before 10, para 10 mile.
Page 44.
That is, I mean, stating about section 313's power. Said that court could have examined under 311 because the court already has the power and that was not utilized by the court. And that is one of the ground that has been set aside.
But the trial court thereafter, my lord, only examined the Mintu Pradhan.
Para 10 is very specific. Para 10 is very specific. Considering the entire discussion, coupled with the legal provisions, I am of the opinion that this is a fit case for remand back to fresh education in the light of the observation made in the discussion. The learned trial court is at liberty to examine further. So, that it is gone,
And like order also, para 10
allowed, yes.
as well as the order portion. Consequently, the appeal is allowed.
Allowed.
What do you mean by appeal is allowed? Appeal is allowed and the case is remanded for fresh trial in the
Fresh
light of the
trial.
observation.
So if that judgment is.
So it was
be
sent
fresh trial.
for fresh adjudication on the basis of the whatever record is already there, those record will be there. That cannot be taken away. That has to be there. And in addition to that, some other materials. And on the basis of the additional materials, the court has passed an order. Now the earlier order has gone, judgment has already gone. The fresh order is the order which is in existence. And whatever, in the appellate forum, whatever adjudication has to be done on the basis of the fresh order only, not on the basis of the order which has already gone.
Fresh order has.
So now again bringing that order and saying that that is upheld and modified, whether that can be done. That is the, contention the learned senior counsel has been raising.
My opinion also subject to correction, maybe remanded back at this stage, whatever the position at that stage, they will again consider, and
Remanded back to,
Messenger.
remand to session judge.
To hear the appeal filed by them.
FS.
I want to show the photographs. He is suffering a lot.
Mr. Doctor, you are a senior counsel now. When don't argue all those things in like when a legal point is being argued.
Yes, my lord, yes, question of law is involved.
See, all these, suffering, all these things, those are there, but those has to be kept in their place where it has to be kept. Not when a legal argument has been made, and those things will not come.
Question of law is involved in this case. My lord.
The will,
I am saying that
anything else you want to argue, Mr. Parasar, you are also of the opinion that this should be remanded back, right?
My lord, but maybe direct it with a direction to complete the matter within.
That, my lord, I have nothing. Your lordship will fix a time frame.
Frame.
And my lord, since we are appealing for both the parties, my lord, a date may be fixed so that on that day the counsel for both the parties will appear, and thereafter a date will be fixed for hearing and matter will be heard, my lord.
Yeah, because this is not a case of trial or anything. It's only
No, nothing has to be done.
only hearing and
No,
argument.
Only hearing
and
the
argument. So,
argument on the appeal.
one hearing or two hearings maximum, not more than that.
My lord.
You also agree to that?
My lord, maybe remanded.
You oppose to this, the proposal, which
My lord,
Mr. Agrawal is giving, or you want to argue on, you want to defend your stand?
My lord, because of the existence of fresh trial, my lord, this is fresh trial in the order, fresh trial. This is some.
It's not only the word. You'll have to see the whole read the whole judgment and see like what exactly the judge was saying. So if you read the whole thing as a whole, then you will find that this has been set aside and this was this was sent back for fresh trial. Not only using of the word phrase. If you do not use the word phrase also, if you read the whole thing, then you will find it out that it was actually sent for a fresh trial.
I don't know, their judgment, if they are at all aggrieved, my lord, of the earlier judgment of the learned session, they could have very well come to this honorable court. They didn't come, my lord, so it reached to a finality.
Now, non-existent existent order cannot be brought in and given effect to that order, which has already been set aside by a competent court with jurisdiction. Okay, we'll conclude it and we'll pass an order. Heard Mr. K.K. Agarwal, the learned senior counsel, assisted by P. Niyok, the learned counsel for the petitioner. Also heard Mr. A.K. Datta, right?
Yes.
Mr. A.K. Datta, the learned counsel, appearing for whom?
Respondent number 2.
Respondent number 2.
No, no, my lord, respondent number one. Yes, for respondent number one. I'm just checking, my lord.
Respondent number one, my lord.
One.
That's what number one.
One and,
One.
one and two,
One and two, my lord.
1 and 2.
and three stated.
State is.
And Mr. KK Prasad, line APP for the state. Arguments concluded, judgment reserved. Mr. Chaudhary is appearing out.
No, in the next.
Oh, you are appearing in a different matter, okay.
Lord,
So,
you would
fine, no?
like to take or will not?
Huh?
The next two matters.
Oh, you also there?
I'm-
Some other day maybe, not today. Maybe in the month of March. Item number 39 and 40. When do you want it, Mr. Agarwal?
Lord,
It's a 19 matter, no, 1920.
19 matter. No, this matter, my lord, in fact, it was had by my lord Justice P.J. Saikia, my lord.
Hmm,
After the matter was not listed thereafter.
okay.
Then thereafter it was listed, my lord, they took some time, again, it was not listed, the matter remained like that. So my friend has made a request, my lord, to the registry to
Mhm.
list the matter because it was pending. My lord, here also the question is very short. Mandatory, my lord, punishment under section 420 of infringement was not given. The punishment was for only fine. That is the basic, my lord, so far my case is, my lord, it's a very short question on that.
So will you list it sometime in the first week of March?
First week may not be possible, my lord. So,
Then-
my lord, your lordship has to accommodate me. Can it be, my lord, then? 10th, my lord, can it be, my lord?
Okay, 10th we'll fix it.
10th.
We are fixing it on 10th.
10th.
Heard Mr. K. Agarwal, learned senior counsel, assisted by Mr. A. Chaudhary, learned counsel for the petitioner.
The other side are not there, my lord.
And the
State
other
is
side-
not a party, it's a complaint.
Other side is not there. When anyways, none appeared for the respondents. In the interest of justice, let the matter be fixed, in the second week we'll mention.
10th March, maybe. Yeah.
Let the matter be fixed on 10th March. 10th March, okay, 10th March.
I'm okay.
If that's 40 and 39 and 40.
But there are two matters, my lord. In second, my lord, we are the respondent. Who is Ekman?
Okay, say.
Well, take together, my lord.
Hmm.
They
One.
have challenged, my lord, the order in revision, my lord, there is, my lord, conviction.
Yes.
Appellate order was
Okay.
challenging.
Okay, 39 and 40, huh?
Lord, we are, my lord, appearing for
In 40 respondent number 2 probably.
Ah.
Respondent number 2.
just and- Oh, I see. Okay. We are respondent number 2.
Yes. In 40, you write that Mr. Agarwal appearing for respondent number 2, huh? And none appeared for the
Petitioner.
petitioner. So both the matters will be listed on the same date, huh? 10th of March. Yes.
Procedure Tanuddin already left the court, my lord, just need personal problem, my lord. This matter may be taken up, my lord, any other day, my lord.
Mr. So-and-so, the learned counsel appearing on behalf of
Petitioner, appellant.
on behalf of the appellant submits that that the conducting counsel in the instant matter has already left the court. Therefore, he prays that the matters may be listed. Matters will be listed in the second week of March.
Only any date.
Let the matter be fixed on 12th of March. 12th.
Lordship may fix the matter second week of March.
Second week of March? Okay.
On 12th, Lordship.
Heard MSS Kanungo for the petitioner and also heard
F. Hussain.
MSF Hussain for the respondent number 2.
Respond to, yeah.
Respondent number 2. Also heard Mr. KK Parasol and an APP for the state. On the joint prayer made by the council appearing for the parties, let the matter be fixed in the second week of March.
A date may be fixed.
Let the matter be fixed on 12th of March. 40 to 43 same. Okay.
DP of legal.